No, I know. I know. We're gonna solve a problem. I know.
On the record in the matter of the people of the state of Michigan versus Antonio Embry, 24-01236, council appearance.
Andrew Stevens on behalf of the people. Morning, Your Honor. Toby White on behalf of Mr. Embry, and he is with me at council table.
Date set for a preliminary examination, and my notes indicate that there's going to be an unconditional waiver.
That's correct. Correct from defense, Your Honor.
An offer at all.
No, Judge.
Sir, you understand that you have the right to have a preliminary examination here in the district court.
That's right.
You understand that the purpose of the exam is to require the prosecution to put forth evidence that would establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You wish to unconditionally waive your exam.
Yes, ma'am.
You understand that you can't take that back once this matter is bound over. You can't decide that you did not want to waive because you don't like your offer. You understand that?
Yes, ma'am.
Okay. What's your P number?
57988. Sorry.
Okay, no worries. It's just someone, it says J White. Should it be J White?
That's J. Toby White.
Okay, very good. Okay. The bind over date is scheduled for the 16th. So that's the date that the circuit court will get the file from this court. That's not a date that you need to appear in circuit court. Okay, sir?
Yes, ma'am.
The next court date will be a pre-trial in circuit court. Mr. White will be made aware of that. You stay in contact with your attorney. The bond was set at 75,000 cash surety. That will continue. Any additional matters for the record?
Nothing from the people, Judge. Thank you. Nothing further. Thank you, Your Honor.
Here. On the record in the matter of the people of the state of Michigan. Versus Devon A. Dillard, 24-02137. Council appearance.
Good morning, Your Honor. Casey Markarian, appearing on behalf of the people. First, making a motion to practice under Michigan Court number 8.122.
An Assistant Public Defender, Sarah Donnelly, on behalf of the defendant, Devon A. Dillard, who is to my right.
A motion is granted. Today was the date and the time that was scheduled for preliminary examination. How are we proceeding?
Your Honor, at this time, Ms. Dillard would unconditionally waive her right to a preliminary exam and have this bound over to the circuit court.
People would also unconditionally waive their right to a preliminary exam.
It's not all in there. Oh, sorry.
Yes. Thank you. Okay, Ms. Dillard, you understand that you have the right to have a preliminary examination in the district court.
Yes.
Oh. I understand that the purpose is to require the prosecution to put forth evidence to show that they have enough probable cause sufficient that a crime was committed and enough probable cause to charge you with the crime.
Yes, Your Honor.
You wish to unconditionally waive your exam?
Yes, Your Honor.
Anybody threatening you to do that?
No, Your Honor.
Is there an offer at all?
Not anymore, Your Honor. There was an offer that was only valid for district court.
So the offer is expiring at the time of the waiver. You understand that?
Yes.
Okay. Bind over date's going to be October 16th. That's the date the circuit court gets to file from the district court. You do not need to appear in the court on that date, okay? Have any questions? Your next court date will be a pre-trial. Your attorney will be made aware of that. Bond is set at 2,000 personal recognizance. That will continue. Any additional matters for the record?
Nothing from the people.
Nothing for defense.
You're all set, ma'am.
Ollie's just gonna be. Your Honor.
You already pulled the Wilson file out. I'm sorry. Did you pull the Wilson file out?
Yeah.
We didn't have to adjust the timeline, did we?
We said you were like, fine.
I didn't do it though.
No, I was.
If you can
It's
grab
in the
the-
clerk's
You can
office.
grab the file. I need to write something in
It's
there.
in the clerk's office.
Dominique Black in here.
Just normal DV if they are.
On the record in the matter of the people of the state of Michigan versus Marcel D'Anthony Carter, 24-02196. Council appearance.
Good morning, Your Honor. Casey Markarian, appearing on behalf of the people.
Goodrich is not here. Okay, okay, and you said Holly was going to be,
Just an adjournment request, Your Honor.
Yes, he is currently in custody. Just asked to be brought up.
we can bring up Holly?
Yes.
What are we doing with Beasley? We running?
Easily. Yes, Your Honor. It's my understanding they want to run that one.
And Jackson as well?
I extended the plea offer again. I believe Mr. Silverthorne is talking to his client on that one. My victim is here and ready to go. We're hopeful to resolve that though. Yeah. Your Honor, I just got informed by Mr. Silverthorne that Harry Jackson should be a plea.
Mr. Raleigh, which matter are you on? And we're running that one, correct?
Yes.
Okay.
Your Honor, my only request, if you would be willing to grant it scheduling wise, as I know an officer, the officer I need for Marcel Carter has to be gone before 11 for some childcare and daycare. Sure, we could do whichever order you want to go in, Your Honor. I just wanted to put that on your radar.
Mr. Goodrich is not here.
Yes, Your Honor. Both of those should be 2 witnesses, Your Honor. I anticipate Carter might be a little longer though.
Okay. So with that, are you ready with your matter?
I have 2 matters.
Okay, you have Jackson, which is gonna be a plea.
Yes, Your Honor. I have Dominic Blackwood, set for sentencing.
Is Blackman here?
He is not.
I issue a bench warrant. I think he's already in warrant status.
I believe, I was informed that he was. One may explain the other.
Okay, absolutely. Okay, we will, get Jackson up right after we take care of Holly. Yes.
Everyone, please make sure your phones are on silent, otherwise you'll be asked to leave the courtroom.
Okay, let's see, I was doing this and on the record in the matter of the people of the state of Michigan versus Terrence Hawley, 24-02773. Council appearance.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Well, thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Holly stands present to my right.
Okay, Mr. Hawley is scheduled for a preliminary examination on 2 counts of criminal sexual crime in the 3rd degree and aggravated domestic violence. And there's a request to adjourn.
Yes, Your Honor. Now, to be blunt, I was running the defendant's jail calls yesterday to see if he had been contacting the victim, and that's how I found out the victim was actually in our jail. I obviously did not have her request her to be brought over from the jail because I didn't know. It wasn't until her number was popping up as being called by Jessica Redmond, that's how I found out. So because of that, Your Honor, I need an adjournment in order to actually make sure she's brought over. I have looked, she will be done with her sentence, should be about 32 days from now. But even if the court is not able to reschedule PE for within that time frame, I'm still going to have someone go out to the jail, speak to her, get good contact information that we can make sure she's here. But obviously, she wouldn't have received her subpoena sitting in the jail.
Thank you. Council.
Thank you, Your Honor. Obviously, I'm going to oppose the people's request for adjournment. Mr. Holly is in custody and not authorized to stipulate to any adjournment, so I would oppose that. I just would note if the court does find good cause to adjourn the preliminary examination, I have a rather extensive trial schedule coming up, so my availability is going to be limited. I do have availability this month on the 17th, the 18th. If the court can schedule it then, and if the court cannot, then I would just be likely that I would have to have someone to cover that exam.
It's needless to say that there's going to be good cause to adjourn. It's not outside of anybody's control that she's in custody. So you have the right to have your exam within 21 days of your arraignment unless you waive the timeline or the court finds good cause. Alleged victim is in jail and it takes time for the court to writ someone, meaning order the jail to send them here for a court appearance. So due to that, I'm going to find good cause to adjourn and reset this matter beyond 21 days. Oh, my PCC. Yeah. Oh, so you can put it in. Yeah. Okay, that's fine.
October 17th at 8:30.
October 17th at 8:30.
And just as a heads up, it's going to end up being someone else covering that for me that day. I also have a truly absurd trial schedule starting on the 14th. So we cannot possibly work around that. I'm just gonna have someone else cover it from my end.
Okay, sounds good. We'll have it scheduled for that date and time. The bond set at 50,000 cash surety with GPS. Other is going to continue the additional matters for the record.
Not for the people, Your Honor.
Nothing on behalf of Mr. Holly.
You're all set. We can bring up,
Yes.
let's see. Jackson. Mr. Freeman, you have Monta Williams with you? Is that who that is?
Yes, Your Honor.
Are we running now?
No, Your Honor, I haven't seen the necessary witness on that, and I'm not proceeding victims.
It's 9:38. If you need to, I'll wait a couple more minutes. It could be
If you wouldn't
more-
mind, Your Honor.
no problem.
An approach, Mr. Jackson, to completion. You're welcome.
Igelson has Zachary Warwick
Should be a waiver, Your Honor.
on the record in the matter of the people of the state of Michigan versus Zachary James Warwick, 24-02821. Appearance, please.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Bigus, appearing on behalf of Zach Warwick, standing to my right this morning, Your Honor.
Okay, Mr. Warwick has a preliminary examination scheduled today for controlled substance delivery. How are we proceeding?
Your Honor, I've had a conversation with Mr. Markarian as well as Mr. Warwick, and just to waive this matter up to the circuit court today.
Would also unconditionally waive their right to a preliminary exam.
May I approach, Your Honor?
Yes. Was there an offer at all?
I believe there wasn't any at this time, Your Honor.
Oh.
Imagine we'll have negotiations. in circuit court.
Your Honor, at this time, there was no offer negotiations coming for so.
Mr. Warwick, you want to waive your exam? Why are you asking him? I'm asking you. Okay, you know the purpose of the exam? Okay, so you do not want the prosecution to put forth evidence at this stage to establish probable cause that a crime was committed and then probable cause sufficient enough to charge you with the crime? Okay, anybody threatening you to waive your exam? Find over dates October 16th. That's the date the circuit court will get the file from this court. You do not have a court appearance on that date, okay? The next court date will be a pre-trial. Your attorney will be made aware of that. You're still at the address on Cooper Street? Okay. Bond was set at 10,000 PR. That will continue. Any additional matters for the record?
Nothing from the people.
Nothing on behalf of Mr. Warwick this morning, Your Honor. Thank you.
You're all set.
Thank you. Oh, you left?
I then left, responded to 3 emails, did a warrant, and now we're back. Okay, let's see, we have, who here again? Mr. Jackson. Okay, Jackson,
Karen, just check the other witness on that.
no problem. Yes, please.
Have a charger. I got one.
On the record, in the matter of the people of the state of Michigan versus Harry Lewis Jackson. Second, 24-02765, Council Terrence.
Morning, Your Honor. Case Markarian appearing on behalf.
Good morning, I'm Wayne Silverthorne from the Office of Public Defender on behalf of Harry Lewis Jackson II. You're standing to my right at council table.
Okay, and Council, you have an advisory rights as well.
Yes, Your Honor.
Please pass it to the court officer.
Didn't indicate that there's any place for them to sign.
Oh, that's because it's supposed to be 2 pages now. So they put the last right at the top of that page now, and that's probably an old one, because I don't know if we still have, do we not have the second page? Is that what's going on?
I have it. He found an old. I found an old one that
Okay.
he could sign, or he could sign that one.
Okay, you'll have to get the new ones from Susan. That one's fine for today, though. You can have him sign that.
Couldn't sign it. I'm not signing
No, he
also.
can sign the old one.
Oh, the old one.
Yeah, because it has all the rights on that one.
Where the X is, that I'll fill it. The date.
She was asking about that.
Okay, so I have an offer here. The people are offering for you to plead guilty to one count of domestic violence, second offense. Under MCL 750.814, that's a misdemeanor, maximum penalty is 1 year in jail and or $1,000 in fines. That's how you want to proceed, sir?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Okay, did you read these rights?
Yes.
You understand them?
Yes.
You're willing to give them up today?
Yes.
That means you're gonna give up your right to the presumption of innocence. You are innocent until proven guilty. You have the right to require the prosecution prove your guilt at a trial by proving each element of the charges being brought against you. You have the right to remain silent at trial and not have silence be used against you. You can waive your silence and testify at your trial if you like. You can have the court subpoena witnesses to trial to testify for you. And you have the right to see, hear, and question any witnesses called by the prosecution to testify against you. So those are all rights you would have to give up. You understand that?
Yes, ma'am.
Is anybody threatening you to get you to give these rights up?
No.
Has there been any promises extended to you in exchange for you entering a guilty plea to the reduced charge?
No, ma'am.
Are you currently on probation or serving a term of parole?
No.
You understand that by entering a guilty plea, it could result in a conviction that may have impact on where you can travel or get immigration status.
Yes, ma'am.
You understand that?
Yes.
It also could have impact on your employment status. You may need to report this conviction to your employer or put it on a future job application.
Yes, ma'am.
Are you entering a guilty plea because you believe you're guilty?
Yes.
As to the amended count 2, well, let's see here. Are we amending count 1? No, count 2. Amended count 2, domestic violence, second offense notice. How do we plead? Actual basis.
Yes, Your Honor. Let's Jackson, we'll take it back just a few weeks. On or about September 13th through the 14th. Were you residing at 3220 Stable Street, City of Lansing,
Yes.
King County, Michigan?
Yes.
Okay, and did you live there with Angela Ralston?
Yes.
And was she your fiance, girlfriend? She's the mother of your 4 children, is that correct?
Yes.
And you had a long-term
25 years.
25-year relationship with her. And on that occasion, did you have an occasion to get into an argument?
Yes.
Okay, and during that argument, in anger, did you slam a door on her leg during that argument?
Yes.
Yeah, hard enough that it caused a small bruise on the lower portion of the leg.
Yes.
Okay, and you knew this was assaultive,
Yes.
and you knew this was offensive.
Yes.
I don't believe any other factual basis is needed, however, if the prosecutor wants to read the enhancement, or I can.
I don't know if that's necessary, Your Honor. The people are satisfied with the factual basis.
There is a factual basis, but it's being charged as a second, and so
I can read the name.
Thank you.
I think it's.
Second offense notice states to take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he or she had a dating relationship with, an individual with whom he or she had children in common with, or a resident or former resident of his or her household, or of knowingly assaulting a pregnant individual.
Any additional factual basis?
Your Honor, people are satisfied.
The court is also satisfied with the factual basis. I'll accept your plea. I find your plea made fully voluntarily and intelligently. This matter is set for sentencing December 5th. 9 o'clock in the morning. We need to meet with our probation department. So they can prepare the court for a pre-sentence interview, okay?
Yes, sir.
In as much as this offense has been reduced from a 10-year assault GBH and a 5-year domestic violence, would the court consider his bond is currently, I think, 10,000 cash surety, moderating that to a degree? He obviously will not be able to go back and live with Ms. Ralston, so he's going to have to fend for himself in terms of housing, and it would help him if he had a more moderate bond, and he would be able to get out and start working and supporting himself.
Yes.
Where is he going to stay?
2114 Delhi Northeast Street, Hope, Michigan. 488.
Whose home is that?
Pardon?
Whose home is that?
My father from another planet. You know what? I'm sorry. No, he's
Which
white.
planet?
I'm just gonna say Earth.
I hope, but you let me know.
He's white, so that's
Okay,
that's where my
okay.
meal goes. So I'm more than welcome to stay.
So let me just be clear. So because he's white, he's from another planet? Is that what
Yeah,
you suggested?
yep. That's exactly what it is.
Oh, okay.
That's exactly what it is.
It's not too late to request competency.
No, I think he probably should just leave where he's left it.
Sounds good. Okay. You need to report to our probation department no later than Tuesday
Yes, ma'am.
at 9, I'll give you 10 o'clock in the morning in
Yes, ma'am.
person, okay?
All right, all right.
What's your phone number?
517-303-0462.
Okay. I'll amend the bond to a personal recognizance, 10,000 personal recognizance. Bond is still, the bond conditions are still including GPS tether with victim notification will continue not to be within 2,000 feet of Miss Angela Ralston. And furthermore, I don't care what planet you're sleeping on, you need to be here for your hearing
Yes,
for
ma'am.
sentencing, and you need to be at our probation department.
15 minutes early. Yes, ma'am.
What day you want to be at probation by?
15 minutes early.
On what day?
Oh, let's see what we got.
By
9
when?
a.m.
By when, sir?
December 5th.
No, I said you, no, you listen to me.
Oh,
You don't listen to him, because right now we're talking. Okay, and we're both sitting here on planet Earth, City of Lansing, Ingham County, State of Michigan. I said you need to report to probation within 48 hours. Why are you reading that when I'm talking to you? Find what? What are you trying to find on there?
nothing.
Listen to me when I'm talking. I'm concerned.
Yes, ma'am.
He can't listen. You need to report to probation no later than Monday, 10 o'clock in the morning in person. Do you remember me telling you that?
Yes, I do.
Okay,
10 o'clock. Sure.
okay. That's so that they can get you scheduled for your pre-sentence interview. Then you need to report here for your hearing December 5th at 9 a.m.
Yes, ma'am.
You understand that?
Yes, I do.
Do you have any questions?
No, ma'am. Thank you.
Thank you. Any additional matters for the record?
From the people.
Nothing from the defendant, yeah.
Thank you. Okay, on the record in the matter of the people of the state of Michigan versus Monta Williams, 24-02236, council appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Assistant Public Defender, appearing on behalf of Mr. Williams, who is standing to my right.
Okay, Mr. Williams was scheduled to have a preliminary examination on assault with intent to do great bodily harm, less than murder, or by strangulation and then a domestic violence third. And the people do not have witnesses today.
No, Your Honor, the necessary witness to this case, Rakisha Singh, has failed to appear, if I may make a record.
You may.
Your Honor, we have attempted to contact Ms. Singh several times. I have left 4 messages myself. Our victim advocate spoke with her and she did not seem interested in pursuing this case or having these charges at all when we initially made contact. Ever since then, it's been voicemail as we sent her a subpoena and she didn't show up. So people are unable to proceed.
Thank you, counsel.
Yes, Your Honor, I move for dismissal without prejudice.
Our motion is granted. The case will be dismissed without prejudice. The people do have the right to reissue this against you, okay? What does mean? Thank you.
Yes.
A copy of dismissal in just a moment.
For just one moment, Your Honor, do I have my officers?
Okay, let's see. So for Carter, we will, he's already waived, the timeline's been waived, so.
First at 9:30.
Yeah. Mr. Stevens is gonna grab the office, just see there's no conflict with the new date, Your Honor.
All right, I just want to make sure.
You don't need us on the record for Wilson, right? That's the one. in
No, I
Winnebago.
found the cause due to just the late notice of him being in the Lego.
Okay. We have a date.
It's
November 20.
November 21st at 8:30.
November 21st.
And then we'll reset, oh, he's getting the officer for Carter.
Yeah.
You just did Jackson. That's-
After that reset, Your Honor, the only things we'll have left are Shaw and Beasley.
That's what I was trying to understand here. I was a little confused about why this is listed as 5 non-public on my document.
She should have crossed it out. It's not.
That was already sentenced. Oh, okay. We're supposed to have a consent hearing on that?
Oh, that's what I was talking about. Office reports.
Oh,
Tried to
gosh.
put the dates on it.
He was arraigned?
Yeah. Actually, I don't know if he was in the most recent one. That it's in the, it's on
Email?
the other side where the sticker.
What day were you looking at, Judge?
I said November 21st.
November 21st.
I think that'll work for both. I was told not the second week of November by one and nothing in October for the other. So as long as we check both of those boxes, that seems
think
to
we made it.
I think we got it too. Wow. Those two were
November
divas back
21st.
there.
At what time?
November
21st at 9:30.
November 21st at 9:30. Mr. Shaw has some newer violations.
The most recent one is the one you think sent, and I
This one?
provided that to council.
Oh, okay.
And Your Honor, if I may, Mr. Shaw, I think the violations all stem from his new pending charges at the 55th District Court.
All of these violations?
Yes.
I believe so, yes.
I see 9/24, 9/14, 9/1. There was another one you said?
The most recent one was the 24th.
Oh, okay. Got it.
It's just cause. it's like-
Nine or 9:30?
9:30.
I told them 9. They'll be here early.
Your Honor, could me and Mr. Markarian discuss the issue with the court and Mr. Shaw before we?
You want to go on the record or not off the record?
I think off the record.
Be here today.
Yes,
Okay.
and Mr. Stevens is texting him right now. He's at Mason. He'll be here in 30.
Sounds good. Is that? Beasley? Okay, on the record in the matter of the people of the state of Michigan versus Willie Paul Beasley, 24-02761 and 24-02336. Appearances for the record.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Jacob Rowley, appearing on behalf of Mr. Beasley, a case file 24-02336 SM.
Morning, Your Honor. Jacob Starnes, the fourth assistant public defender here on behalf of Mr. Beasley for the felony.
With the date that is scheduled for a preliminary examination, the final pretrial in the PA 53 contempt hearing. How are we proceeding?
Your Honor, at this time, we have not seen the necessary witness for the final pretrial. However, the people are ready to proceed on the PA 53 and the preliminary exam. We'll be doing so under 27C.
Your Honor, for my part, that would be moving for dismissal of the misdemeanor files with the associated P53.
Your Honor, to be clear, I can proceed on the PA 53 under 27C as well, so I'd object to a dismissal on
And I believe
the same facts as the preliminary exam.
Thank you.
I believe, well, to begin with, I think the burden of proof is higher with regard to it's a reasonable doubt standard rather than should be probable cause. I believe the state of case law is that confrontation does apply in that situation.
What case law?
It'd be the only case, which people be only, which I believe established in Michigan that the 27C law can be used for.
I'm sorry, the door was closed and someone laughed and your voice is so low.
Sorry. People be only, which I believe is confirmed that 27C is valid for purposes of establishing probable cause for a preliminary exam, but not at trial.
PA 53 is not a trial, Your Honor, it's a contempt. There's no confrontation.
But I believe it is essentially a trial in the sense that it is a judgment of contempt that requires a finding of guilt beyond a reasonable doubt, much higher standard than simply probable cause.
I recognize the standard is beyond a reasonable doubt, but the standard is still, well, it's still not a trial. There's certain other rules that come along with the jury trial that are not afforded to a contempt hearing for a reason. It's not a trial. It's just the court has to make a determination beyond a reasonable doubt. I don't believe my interpretation of only would is not that confrontation would apply just because of that. It was specific in the language as to trial. It didn't say anything about a contempt hearing or any hearing. It's just stated trial. So for that purposes, I am going to grant you request to dismiss the domestic violence without prejudice. However, we can proceed on the PA 53 as well as the preliminary examination, recognizing that the burden on both of those, although it's the same set of facts, but the burden on one is higher. That's still up to the prosecution, okay? Any other matters before we call witness?
Your Honor, I don't know if you want to, but for judicial economy and efficiency here, I think we should get all the 27C objections to hearsay, any objections to the 911 call or anything to play out of the way. I can make a motion for all that.
Okay, you can proceed.
Your Honor, at this time, the people would move to include allowance of testimony by Officer Stevens to all of the statements contained within the police report that we have on this case of the victim, LaTanya Burnett, pursuant to 27C. Your Honor, all of these statements that she made pursuant to only in the statute do narrate, describe, and contain instances of domestic violence. Therefore, we should be able to proceed without any hearsay objections to all of those statements regarding the 911 call that I have pulled here. It's actually a call from the defendant himself, where he identifies himself on the phone call, as well as identifies the victim, LaTanya Burnett. And I would intend to play this 911 call in its entirety because it includes, if I may proffer, Your Honor.
Okay.
It includes statements from the victim on this, specifically stating she can't breathe and she needs help, to the point where dispatch had to interrupt Mr. Beasley and ask them who that person in the background asking for help, stating they can't breathe was. I think all of these are admissible pursuant to 27C and not hearsay for those reasons, or admissible hearsay, I should say.
Counsel.
Your Honor, I simply renew my objection on the basis of hearsay.
And for the purposes of felony charges, Your Honor, respectfully, that's would object to the request to introduce the statements pursuant to 768-27C. We will object on grounds of lack of reliability, lack of foundation, lack of further, Your Honor, lack of sufficient possible reliability too, as relates to the concerns about this witness's motivations to possibly have lied or misrepresented her statements during her actions and conversations with the police officer. And respectfully, we haven't heard the factual basis yet for why the prosecutor is going to actually seek the introduction and have received testimony from the officer. So at this point, on the felony side of things, defense counsel would also state objections to the request to introduce those statements. Further, Your Honor, respectfully, these statements are testimonial. We do think there are confrontation clause rights implicated, albeit only did clarify that according to the Supreme Court here, they don't consider preliminary examinations to be a setting where Mr. Beasley would have the right to confront his accuser. But even with that, Your Honor, still I'd like to raise the issue, preserve the issue in case down the road that opinion changes. Thank you.
Your Honor.
You may.
Your Honor, while I understand reliability is inherently a question with hearsay, it is not an objection to hearsay, nor is credibility. Those are both issues for weight, not admissibility. They don't affect whether or not this testimony comes on. In fact, 27 MCL 768.27C addresses those issues about inherent reliability. I understand the foundation objection because we haven't presented a witness yet, but I'm confident that I will be able to lay the necessary foundation through Officer Stevens, who is here present. That's why I was just trying to address this as a motion and eliminating, kind of get all this out of the way before we start.
Thank you. Thank you. As to the objection by Mr. Raleigh, it's overruled because MCL 27C allows for it to come in as hearsay. So to the extent that you're trying to preserve that in case the Supreme Court overturns it, it's overruled. You made your objection. I'm going to hold your objections in advance because I think I need to make a ruling after the evidence is played out. Any other preliminary matters before you call your witness?
Your Honor, I just have some photographs. I didn't know if there would be any stipulation to these.
Thank you, basis. Respectfully. Thank you.
Yes, I can lay the foundation for the witness, Your Honor. It's fine. We're ready to proceed. The people call Officer Stevens, Officer Matthew Stevens.
You can have a seat.
Oh, okay.
To be clear, Your Honor, to be clear, did you hold the objection on the 911 call in advance as well? Or is that admitted?
His objections, I think, was to all of the evidence that you were trying to admit, is my understanding.
Correct, Your Honor. For the purposes of felony file, I'll just object to everything potentially coming into preservation.
Fair enough, Your Honor. I'll lay the foundation.
Okay, thank you. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury.
I swear.
You can have a seat. Please state your first and last name and then spell both.
First name's Matthew, last name Stevens, that's MATTHEW STEVENS.
Thank you, proceed.
Thank you, Your Honor.
Good morning, Officer Stevens. Thank you for being here. Are you currently employed?
Yes, sir.
Where?
With the City of Lansing Police Department
How long have you been employed with the City of Lansing Police Department?
for almost 4 years.
What is your current rank and assignment?
Currently with the Patrol Division as a patrol officer.
Have you been assigned to patrol for the entire 4 years you've been on the force?
Yes, sir.
Could you generally describe what your duties as a patrol officer are?
Responding to calls for service within the City of Lansing Police, or within the City of Lansing.
Now, I'm going to ask you a question that trips up people sometimes, and it's fine if you want to approximate. How many times, if you know, have you responded to an incident of domestic violence?
Too many, sir. Time.
More than 100?
Roughly, yeah.
More than 500?
Not.
Fair enough. So somewhere above 100 calls.
Yes, sir.
Officer Stevens, are you familiar with a person named Willie Beasley?
Yes, sir.
How do you know Willie Beasley?
From a call for service that is present.
Would you recognize Willie Beasley if you were to see him again?
Yes, sir.
Do you see Willie Beasley in the courtroom with us today?
Yes, sir.
Could you please point him out and identify him by an article of clothing he's wearing?
It's the gentleman with the short sleeve shirt that's blue in color with buttons.
Your Honor, please let the record reflect the witness or Officer Stevens has identified the defendant.
Identification is noted.
You said you responded to a call for service. Was that at the location of 1501 Kennedy Drive in the city of Lansing?
Yes, sir.
Is that located in the county of Ingham?
Yes, sir.
State of Michigan?
Yes, sir.
Would that be on the date of September 13th, 2024?
Yes, sir.
Now, before we get to what happened when you actually got there, I want to talk about what information you had on the way there. Did you have some information from dispatch about this call?
Yes, sir.
What was that information?
It originated as a trouble subject in the call that was received by dispatch. They could hear someone in the background saying, "I can't breathe."
Objection, Your Honor, because we're getting into hearsay now, statements from dispatch to this officer. Thank you.
Did you want to respond to the objection?
Yes, sir, and I'm not using those particular statements for the truth of the matter asserted. I have the 911 caller here. We're just using it for next steps and foundation.
Objections overruled.
Now, you mentioned dispatch informed you about a call where someone was heard saying that they couldn't breathe on it. Have you listened to that 911 call?
Yes, sir.
Did we listen to it today?
Yes, sir.
Right before you testified?
Yes, sir.
Are you familiar with the contents of that 911?
Yes, sir.
Would you recognize it or would it? Let me ask you this way. I'm going to approach with People's Exhibit number 1. It's a flash drive containing the 911 call. Is this the flash drive that we listened to earlier?
I believe so, sir.
And what was on that?
It was dispatch information for the call for 911.
Do you know if the defendant identifies himself on this call?
Yes, sir.
Do you know if the defendant identifies anyone else on this call?
Yes, sir.
How do you know that?
He mentioned the female's name was Tanya Burnett in the phone call.
Turn at this time, and you can play it first if you like, but I would move to admit People's Exhibit number 1. I think between 27C and the foundation that's been established here on the record, it is admissible.
Mr. Sutts.
Thank you, Your Honor. Defense would object to the introduction of this call. This particular officer is not the officer who received this call initially. Further, Your Honor, lack of foundation on the grounds this officer, there's been no testimony that this officer ever talked to Mr. Beasley, knows what Mr. Beasley's voice actually sounds like, can properly authenticate that it would be Mr. Beasley's voice on this call. So not only is this officer not the 911 operator who took the call in the first place, so lack of foundation there, but he's also not the officer who would have had any prior conversations, would have been able to recognize what Mr. Beasley's voice sounds like, or had any previous interactions based on the testimony so far that would suggest that he could properly authenticate that it was Mr. Beasley's alleged voice on that phone call. Thank you.
Mr. Markarian.
Yes, Your Honor. I am looking at MRE 901B1, 901B6, both for testimony of a witness with knowledge under B1 and evidence about a telephone conversation under B6. Your Honor, specifically looking at B6, it states For a telephone conversation, evidence that a call was made to the number assigned at the time to A, if a particular person, if circumstances, including self-identification, show that the person was the one that called. On this call, not even a minute into it, the defendant identifies himself. This is a,
Record. The screen always goes out when it gets really juicy, so.
fair enough. I'm gonna go, I need to connect to the Zoom room anyways, Your Honor, so that's okay.
Hi, this is Judge Simmons. How are you? Oh, yeah, I'm actually in the middle of an exam, but. Okay, back on the record, you can continue.
Yes, Your Honor, thank you. So I left off at talking about MRE 906 B or 901 B6 A. If a particular person, if circumstances, including self-identification, show that the person was the one that called, is a option for authentication and identification of this evidence, Your Honor. The defendant identifies himself on the phone call within a minute of the phone call starting while talking to dispatch, as well as the victim, Latanya Burnett. Not only that, Your Honor, I could even, if the defendant didn't identify himself, would have had enough testimony under MRE 901 B1 to admit this. Officer Stevens has testified he has knowledge. He has listened to this call. He responded to the call itself and the dispatch. I could ask the foundational question of if he made contact with the defendant, if you'd like, Your Honor, to make it clear, but I think it's more than assumed at this point.
I don't think any additional foundation is necessary. It's admitted. Oh, and the objection is overruled.
Thank you, Your Honor. This time, just requesting permission to play the 911 call for the court.
Permission granted, and I made you co-host.
Thank you, Your Honor. playing People's Exhibit number 1, Your Honor.
911, what is the location of your
Yes,
emergency?
ma'am, she is staying here and she made it back to my place and she is not supposed to be here.
What is the
She
address?
is causing a ruckus and everything. My name is Willie Beasley.
Sir, what is your address?
My address is 1501 Kennedy Drive.
Is that a house or an apartment?
It's an apartment house. I can't breathe.
Do you have a room number?
There's no number.
Okay, what street crosses with Kennedy?
It's gonna be off of Hag and Kennedy, 1501.
What's your phone number?
813-440-1546.
Okay, and what's going on with this person? Why are they saying they can't breathe?
Well, she's saying she can't breathe because I'm trying to keep her calm because she's tearing up the house again. She's doing it over and over again.
Does anybody need an ambulance?
No ambulance is needed.
Okay. What's this female's name?
She's Latanya. She came back over to my place, and she's not supposed to be here.
Okay, Willie.
She's tearing up things again.
Sir,
I need help. She is tearing things up.
Away from her. Just walk away.
I am.
You're screaming into the phone. I need you to take a deep breath. What's this person's name?
You're tearing up everything.
Okay, Willie, let her do that, okay? We're going to get the officers over there to mitigate the situation. Can you walk outside and stand on the front porch?
I can. I'm walking outside.
Okay. What's this person's name?
I'm sorry?
What's this person's name?
Latanya Burnett. She's not supposed to be here.
Okay, I understand that she's not supposed to be here, okay? How do you spell her first name? Willie, how do you spell her first name?
Latanya. 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 Latanya.
Okay, what's her date of birth?
Her date of birth is 2/7/73.
Okay, is she white, black, Asian, Hispanic?
Yeah, she's mixed. She's black.
Okay, what color shirt is she wearing?
She just left out the door now, so she's wearing a black tank top t-shirt.
What color pants?
Black also as well.
Okay. Does anybody have a weapon?
No, nobody has a weapon.
Okay. What was she saying about he's trying to kill me?
Yeah, she said I was trying to kill her, but she came here and started causing a ruckus about, saying that I have her keys and stuff like that, and all she's trying to do is move. But I don't have any of her belongings here. So she could continue to get aggressive about it.
Okay. And what's your last name?
Beasley. My last name is Beasley.
Okay. All right. I have a call in for service, okay? I want you to stay separated from her. You said that she walked out the front door?
Yeah, she's coming back in now, so I don't know what am I supposed to do?
Close the door and lock
She
it.
just walked in. She have keys. She got different keys to come here.
Okay. All right. Willie, I want you to stay separated from her until police can come and mitigate the situation, okay?
Okay, thank you.
You're welcome. Stay separated from her.
For the record, Your Honor, that was the entirety of People's Exhibit number 1. It's a 911 call dated September 13th, 2024, placed at 11:29 p.m. It's 4 minutes and 7 seconds long. Officer Stevens, what did we just hear on People's Exhibit number 1?
The 911 recording.
Objection, Your Honor, because again, he didn't receive this call. All he's doing right now is testifying about what he has observed later on about the recordings of this call. So I will just state my objection on the grounds of lack of foundation, lack of personal knowledge. And just to preserve the issue. Thank you.
Do you want to respond to the objection?
Again, Your Honor, I think we've laid the foundation. I think the objection's been overruled at this point. There's no need to continuing making the objection that's already preserved on the record, I believe, under MRE 103.
Thank you. Objections overruled. You proceed.
What do we hear on that call?
Mr. Willie Beasley calling 911, saying there was an unwanted as residence at 1501 Kennedy Drive. There's a female that you heard in the background saying, "I can't breathe." Mr. Beasley identifies the female as Latanya Burnett.
I'm going to play that portion again where the female is speaking in the background because I think it was a little difficult to hear. And that's not the entirety of the call. Playing People's Exhibit number 1 again from the start.
911, what is the location of your
Yes,
emergency?
ma'am, she is staying here, and she's made it back to my place, and she is not supposed to be here.
What is the
She
address?
is causing a ruckus and everything. My name is Willie Beasley.
Sir, what is your address?
My address is 1501 Kennedy Drive.
Is that a house or an apartment?
It's an apartment house.
Do you have a room number?
There's no number.
Okay, what street crosses with Kennedy?
It's gonna be off of Hag and Kennedy, 1501.
What's your phone number?
813-440-1546.
Okay, and what's this person, what's going on with this person? Why they can't breathe?
Stopping People's Exhibit number 1 at 54 seconds. What, if anything, did the dispatch interrupt and say at that point, Officer Stevens?
She inquired as to why there's someone in the background saying they can't breathe.
Eventually, did you respond to the location of 1501 Kennedy Drive based on this call?
Yes, sir.
Did you obtain a statement from that person that we heard on the phone call saying she can't breathe, Latanya Burnett?
Yes, sir.
What did Latanya Burnett tell you had happened?
Latanya Burnett advised that she had returned home from work. Upon returning home, she made contact with Mr. Willie Beasley, who was already home at 1501 Kennedy Drive. At first, it started off as a conversation between the two, but escalated into an argument between a set of keys. The argument continued to escalate until ultimately Willie Beasley had thrown Latanya Burnett onto the ground. Immediately preceding that, Willie Beasley had gotten on top of Latanya Burnett and wrapped his arm around her throat. During that time, Latanya advised that she had difficulty breathing and had possibly lost consciousness. Latanya remembered Willie getting on the phone with someone, so she advised that she had said, "I can't breathe," in hopes that someone would hear. During that time, she tried to fight him off them, and about as much as she told me.
Thank you. Now, I want to break that down a little bit. You mentioned that she had gotten home and Mr. Beasley was already there. What, if any, information did you uncover throughout your investigation on whether or not Mr. Beasley was allowed to be at this home or near Miss Burnett?
That there is a valid PA 53 through the 54A District Court protecting Latanya Burnett from Willie Beasley.
In your training and experience as an officer, would Willie Beasley being in Latanya Burnett, the same home as Latanya Burnett, be a violation?
Objection, Your Honor, calls for a legal conclusion.
Did you want to respond?
Your Honor, I understand the objection, although I don't think this is necessarily a legal conclusion, nor does it require legal knowledge to testify to the fact that being in the same home as someone that you have a no contact order with is a violation.
Well,
I can withdraw.
your question was whether or not, repeat what your question was specifically.
My question was, based on your training and experience, would being in the same home as Latanya Burnett be a violation of this order?
I think the way it's phrased is appropriate because that would also explain if the officer took action, maybe to take the subject into custody, why he did that. So the objections are ruled.
Thank you, Your Honor. So what, if any, information, or in your training and experience, would this be a violation of those conditions?
Yes, sir.
Was Mr. Beasley taken into custody for this?
Yes, sir.
Now, I want to talk about what Latanya told you a little bit. What, if any, difficulty breathing did she describe?
She had soreness on the throat, difficulty breathing, had a raspy voice.
What, if anything, did she tell you about a possible loss of consciousness?
That she had difficulty or difficult time remembering if she had lost consciousness.
What, if anything, did she tell you about other injuries she had sustained as a result of this assault?
That she had numerous scrapes on her left bicep, as well as a small laceration on her right hand. She had bruising on the left side of her neck, and also an abrasion on top of her head from a wing being ripped off of her.
Did you take photographs of this?
Yes, sir.
Do you recognize those photographs if I approach you with them?
Yes, sir.
Showing to opposing counsel, exhibits 2, 3, and 4. Approaching the witness. Just take a moment, flip through all those photos for me, and then when you're done, just look. You recognize those photos?
Yes, sir.
In people's exhibits 2, 3, and 4?
Yes, sir.
Who took those photos?
I did.
What do those photos show?
Latanya Burnett's injuries.
Your Honor, at this time, are those fair and accurate depictions of how Latanya Burnett appeared on the night and time you took those photos?
Yes, sir.
Your Honor, at this time, people would move to admit exhibits 2, 3, and 4.
Any objections?
Your Honor, not at this time. Thank you.
2, 3, and 4 are admitted.
Officer Stevens, you described some hand injuries, an abrasion to the head, some swelling or redness to the throat. Where can you see that in those photos? Feel free to mess around with them, play with them, and show the judge.
Your Honor, so top here is the abrasion to Latanya Burnett's head from her wig that was glued to her head being ripped off. On the left side of Latanya Burnett's neck, there was some minor bruising near the throat itself, as well as kind of closer to her upper chest there. On her left arm was scratches near her bicep, kind of going towards her tricep on the exterior of her arm. And then on her right hand, near her ring finger, there was a small laceration.
Thank you, Officer Stevens. Might be another odd question for me here, but what, if any, evidence did you uncover that the defendant did this in self-defense?
Can object on the ground of that would call for speculation, Your Honor.
Well, we don't know if it calls speculation because he asked what, if any evidence, and it could be that he was given such evidence. So the objections are ruled.
What, if any, evidence did you uncover throughout your investigation that the defendant did this out of self-defense?
As far as I'm aware, there wasn't any of those out of self-defense.
What, if any, evidence did you have that Latanya Burnett asked for all this to happen?
There was none.
What, if any, evidence did you have to suggest that this touching was accidental?
There was none.
Thank you, Your Honor. At this time, I have no further questions. Permission to publish exhibits 2, 3, and 4 to the judge or the bench.
Cross-examination.
Morning, officer.
Good morning.
Personally did not witness any sort of assault between these two individuals, is that correct?
That's correct.
You mentioned some bruises, some abrasions. Of course, you did not see how those occurred or what caused those yourself, correct?
I did not see how this specifically occurred.
And there's some mention of a PA 53 order. Do you recall whether that order specified that Mr. Beasley was not to be at a specific address?
There was no specific address for it, but it said not to be within 2,000 feet of where Latanya Burnett resides, lives, or goes to work or school.
And what evidence did you find, if any, that Ms. Burnett does reside, work, or go to school within 2,000 feet of where Mr. Beasley is located?
Based off of her verbal confirmation that that's where she lives, she had a key to the residence. After Mr. Beasley was taken into custody, she advised there's multiple property inside of the living room area that was her property.
No further questions, Your Honor.
Thank you, Your Honor. Just to follow up briefly, officer. She was very hard to hear when she was trying to talk to you, correct?
Yes, sir.
Okay, she spoke in very low tones, her voice was very raspy.
Yes, sir.
correct? And you recall what approximate time this was as well?
Approximate time for the call for service?
Yeah.
Or for when? the incident
Approximately
occurred?
what time did you respond?
Approximately 11:30 p.m.
30 p.m. Did she ever give you a time frame as to when she claims these allegations occurred?
Not necessarily, no, sir.
Okay. And in terms of your interactions at the scene, you never talked directly with Mr. Beasley, correct?
No, sir.
So you can't really say that you have ever heard Mr. Beasley's voice, correct?
Prior to the incident, no, sir, but I had interaction with them with taking them into custody. During that time, we had,
All I asked you was, okay, just narrow this down.
Yes, sir.
You didn't talk to Mr. Beasley when you arrived at the scene,
No,
correct?
sir.
So, and how many Mr. Beasleys are there in the Lansing area to the best of your knowledge?
Honestly, this is the first time I've dealt with Mr. Beasley.
Okay, so you don't know if there's other Mr. Beasleys or anybody else, correct?
I do not know.
And in terms of the 911 call, again, you weren't the operator who took the call, correct?
No, sir.
All right. And you heard Mr. Beasley's account on that 911 call, or the person who claimed to be Mr. Beasley, correct?
Yes, sir.
Did you go through and did you find a knife at that location?
No, sir.
Did you ever look for a knife inside the location?
I do not know personally.
Okay. Did you check Miss Burnett for a knife?
No, sir.
Did you ever bother to even, talk to Miss Burnett about whether she had a knife?
No, sir. I was unaware of this knife.
Okay, so you never bothered to actually investigate, the version or anything else of a possible sort of self-defense claim or anything?
Mischaracterizing the testimony here, I think, saying that he didn't even bother to investigate is a bit wrong. He went there. He looked
Okay.
at the scene.
But you gotta rephrase.
Yeah, thank you, Your Honor. I'll rephrase. Did you personally inspect Mr. Beasley for injuries?
I didn't speak with Mr. Beasley. There's another officer on scene with me.
Okay, so you don't know if Mr. Beasley at the time had any injuries, correct?
No, sir.
So you testified here earlier that you thought it might have been in self-defense, correct? That it was not in self-defense, excuse me, I don't want to mischaracterize what you said, that it was not in self-defense, correct?
Yes, sir.
But you didn't do any investigation in terms of checking her to see if she had any weapons, correct?
No, sir.
You didn't do any investigation in terms of Mr. Beasley to see if Mr. Beasley had any self-defense wounds or anything along those lines, correct?
I did not speak with Mr. Beasley, sir, no.
Okay, so your testimony here about how you didn't think it was in self-defense, that was just purely your guesswork and due to entirely based on Miss Burnett's statements, correct?
Yes, sir.
So you didn't bother to investigate, for example, if the touching was accident, did you?
No, sir. So I did not speak to Mr. Beasley, sir.
Okay, so you only talked to Miss Burnett when you responded to the scene, correct?
Yes, sir.
And the extent of your testimony here relies entirely on what Miss Burnett told you, correct?
Yes, sir.
And had she been drinking that evening?
As far as aware, yes, sir.
Okay, and had she been smoking marijuana or using any other substances to your knowledge?
I do not know, sir.
Did you know, for example, if she had maybe a mental health condition that might have impacted her memory or her ability to recall the events then?
No, sir.
Did you bother to investigate those issues?
No, sir.
Okay. And so you don't have an approximate time, again, correct? That's what you testified to her.
Yes, sir.
All right. And did Miss Burnett ultimately seek any sort of medical treatment to your knowledge?
Yes, sir. There was an ambulance that arrived on scene, sir.
Okay. And but at the time, though, she declined medical treatment, correct?
She declined transport to the hospital, yes, sir.
Nothing further. Thank you.
Yes, Your Honor. Thank you. Officer Stevens, you were asked a lot about things that you didn't do on cross-examination. Was there someone else with you?
Yes, sir.
Who?
Officer Osentowski.
Do you know if Officer Osentowski spoke to the defendant?
Yes, sir, he did.
Do you know if Officer Osentowski took photographs of the defendant?
I believe he did, sir.
Have you seen those photographs?
I have not.
Objection, just in terms of lack of foundation, lack of personal knowledge as it relates to Officer Ostenkowski's potential involvement. Thank you.
I don't know how you can say what the other officer saw, so I'm going to sustain the objection.
Recognize the foundation, Your Honor. Thank you, Your Honor. When you investigate with a partner on a scene like this, are you within seeing distance of Officer Osentowski?
Like close distance, yes.
Can you see what he's doing?
Yes, sir.
Can you hear what he's doing?
To a certain degree.
Clearly. Can you hear well enough to hear that he is having a conversation with Mr. Beasley without specifically stating any statements that were brought up or elicited in it? Could you hear that he was talking to Mr. Beasley?
Yes, sir.
Could you also see that he was taking photographs of Mr. Beasley?
Yes, sir.
Thank you, Your Honor. I have no further questions.
So Stevens may be excused. Do you have any other witnesses?
One moment, Your Honor. For the witnesses, Your Honor. Officer, for the record, Your Honor, Officer Osentowski was subpoenaed for this examination. I received an email from him late last night stating that he had headaches, body aches, a fever. He didn't know how he was going to feel when he woke up. So that's why he is not here. Regardless, Your Honor, I think we've got more than enough for probable cause to move into argument.
Is the defense calling witnesses?
No, Your Honor. Not for the preliminary examination, Your Honor. Thank you.
Thank you, Your Honor. As Your Honor is well aware, we are here for a preliminary exam regarding Willie Beasley. Standard is probable cause. I have to prove that a felony was committed, specifically assault with intent to do great bodily harm, less than murder by strangulation or suffocation, and that by a probable cause standard, this defendant is the one who committed that felony. Count 2 is a domestic violence misdemeanor that will automatically transfer upon bind over. We also set for a PA 53 hearing. We took testimony for all of that at the same time for efficiency's sake. Your Honor, regarding assault with intent to do great bodily harm, less than murder by strangulation or suffocation, I'm looking at Michigan Criminal Jury Instruction 17.35. I have to prove 3 things to you today: that the defendant committed a battery on Latanya Burnett, that the touching was intended by the defendant, meaning not accidental, and that it was against Latanya Burnett's will, and that the battery was committed by strangulation or suffocation. Namely, that it intentionally impeding normal circulation of the blood or breathing by applying pressure on the throat or neck or by blocking the nose or mouth. Your Honor, we heard from Officer Stevens about his investigation. And I would say maybe most importantly, which it seems perhaps was missed during cross-examinations, we heard the 911 call. We heard exactly what happened while it was happening. This defendant called 911 himself, trying to call on the victim in this case, Latanya Burnett, trying to report that she was acting crazy and he was just trying to control her again. Your Honor, the way that he went about controlling her was discovered by Officer Stevens pursuant to his investigation, and you can hear her saying it on the phone call essentially. He had his arm around her neck and was strangling her. You can hear her plead with 911 several times in the background to the point where the dispatcher interrupts the defendant and asks who is in the background and why are they saying they can't breathe. She said several times that she couldn't breathe. She also told Officer Stevens that she possibly lost consciousness. She asked and pleaded and begged for help on that 911 call. She told Officer Stevens when he arrived that she heard the defendant on the phone with someone and started pleading for help, saying she can't breathe in hopes that someone would hear her. Well, someone did, and officers got dispatched to this location. Upon the arrival, they made contact with Latanya Burnett, who confirmed exactly what happened to her. That when she got home, the defendant was already there in violation of his PA 53, preventing him from having any contact with Latanya Burnett or being within 2,000 feet of where she lives, works, or goes to school. We've established through Officer Stevens, frankly, through cross-examination, that there was property and plenty of evidence to indicate that Latanya Burnett was staying there, that she was a resident of this house, that she said she was a resident of this house as well. That's a violation of the PA 53, Your Honor, there, cut and dry. Not only that, another condition was not to assault, harass, intimidate, or threaten Latanya Burnett, and he did exactly that. When, as Officer Stevens told you, Latanya Burnett described her getting home, there being an argument over a set of keys eventually after they had both had drinks. Then he jumps on top of her when she says she's going to leave the house, wraps his arm around her throat, starts strangling her to the point of almost or possibly losing consciousness. Then he's not done yet because he chooses to rip her wig off, causes lacerations to her body, and Your Honor has photographs of exactly where that wig was ripped off that was once glued on. Your Honor, it's a probable cause standard. The 911 call by itself could have gotten us probable cause. What we heard from the defense was claims of self-defense that are affirmative defenses that would be great to raise at a trial and try to show or have us disprove there, because it is our burden ultimately. But those are trial issues in affirmative defense. There's nothing to do with probable cause or preliminary examination. I'm sure we will have Officer Osentoski if needed when it comes to with that you'll risk.
As to opposing bind over, Mr. Chair.
Specifically as it relates to the felony charges, Your Honor, that's to object to the proposed bind over here. In contrast to the depictions of the prosecutor, respectfully, I think there are serious questions about the reliability and credibility of Mrs. Barnett's alleged statements, as well as the investigation that was done here by this particular officer, Mr. Stevens. Reliability and credibility is a consideration in terms of whether to admit the statements under MCL 768 and 27C. And respectfully, clearly, there are a lot of questions about Ms. Burnett in terms of her motivations, about why she would describe the particular way that she described the allegations here, what her motivations were, what her potential biases were. The 911 call respectfully raises further doubts. Whoever made that call, someone identified it, Mr. Beasley. Again, we didn't have the person who actually took that call, nor did we have a person who actually talked to Mr. Beasley, who was claiming that this call self-identifies, or that was Mr. Beasley on it. But nevertheless, it was admitted into testimony, Your Honor. Clearly, there are doubts too about whether Ms. Burnett possibly had some motivations and concerns about her own self-interest in light of the allegations here. This particular officer testified that he didn't see any evidence of any self-defense, but on the other hand, he also didn't bother to investigate any of those claims or any concerns or any, possible, issues with self-defense or accidental touching or anything else along those lines. Instead, he showed up and basically entirely relied on Ms. Burnett's statement and bothered to do any sort of a further investigation, despite potentially conflicting information in terms of the situation he was responding to. And further, Your Honor, in terms of this witness's credibility, Officer Stevens, we don't know the home address of Ms. Burnett. According to him, it was basically wherever she said it was going to be, essentially. And of course, the prosecutor's position is going to be on it, that it was clearly established at this particular address, based on her statements through Officer Stevens. But respectfully, there are some doubts about her credibility here in terms of where she was living or where she was purporting to. Now, granted, the testimony through Officer Stevens was that she claimed that she had some personal items in the bedroom or wherever else, but still, in terms of the order itself, we don't have an address apparently, and the officer could not testify as to where she was living as it relates to the PA 53, which again raises doubts about his credibility. Also, the complaining witness here as well. Respectfully, Your Honor, the story itself from Ms. Barnett, translated and testified to through Officer Stevens, the story itself, even taken at its face, certainly raises some concerns about the description. And all in all, Your Honor, the prosecutor has failed to meet the probable cause standard here based on the statements from Officer Stevens. Thank you. And the defense would continue our objection based on the 768 20C statements coming in just to preserve the issue. Thank you.
May I respond, Your Honor?
Yes.
Your Honor, looking at MCL 768-27C, I'm looking right at section 2, which describes what may indicate trustworthiness, as that was brought up on closing. Looking at 2C, whether the statement is corroborated by evidence other than the statements that are admissible only under this section. Your Honor, you have the photographs right in front of you. She said her wig was ripped off her head. She said she was choked and there's swelling in those photographs. She said she had lacerations as a result of this attack. And that's what we have. It's corroborated by other evidence. It was corroborated by the investigation. It is inherently trustworthy due to the corroboration, not to mention we have a 911 call where frankly, I don't even know why we're trying to contest that it's Mr. Beasley on the call, although I understand they have a job to do. He says his own name and calls 911 himself, then identifies Latanya Burnett, who's in the background saying she can't breathe, saying she needs help. And then officers respond to a location and they're both there as if this is all just some coincidence. And it wasn't Willie Beasley who made the phone call. Your Honor, regarding probable cause, there's more than sufficient probable cause. Like I said, the 911 call by itself might be probable cause. Regarding beyond a reasonable doubt for the PA 53, as is the standard for that, I don't know why we have constant PA 53 hearings where it seems like the understanding from the defense bar is that the only term on those is that they're not supposed to be where they live, work, or go to school. To be clear, there were 3 conditions on this bond that he was in violation of all 3. Number 1 being not to assault, harass, intimidate, or threaten Latanya Burnett. He did that beyond a reasonable doubt. Number 2, not to have any contact with her. He did that and admitted to it on the 911 call that we're supposed to think is not him. Number 3, he's not supposed to be within 2,000 feet of where she lives, works, to go to school, and we've got evidence proving that. Your Honor, there's more than enough to bind this case over. There's more than enough to find him in violation of the PA 53. Thank you.
Mr. Rowley.
Well, Your Honor, with regard to the alleged PA 53 violations, I think one alleged violation that at least in the report that was provided to me was that my client had used alcohol. No evidence of that was presented today. So I'll move on from that. As far as any sort of harassing, intimidating, threatening, assaultive behavior, again, the only evidence we have is the hearsay, which I understand, of course, 27C. I, of course, preserve my objection to that. I think there are clearly questions regarding credibility, reliability, motivations of the complaining witness, Latanya Burnett. I'd love to examine those issues on cross-examination. Of course, that's not an option we have today. And with regard to being within 2,000 feet of where she works, lives, or goes to school, again, we have sort of these statements that she had possessions there. That's supposed to establish that she lived at this address of 1501 Kennedy Drive. Of course, the PA 53, as we heard from Officer Stevens, did not list that as her address. What we have heard is that Mr. Beasley called 911 and reported an unwanted person in his home. Certainly no indication that he initiated, invited, or wanted contact with Ms. Burnett. In fact, the only evidence we have is that he did not want that contact. He did not want it to continue. We hope that the police would help him to end it. For all those reasons, Your Honor, I would ask that you find my client not guilty of these alleged PA-53 violations.
The court is here for two purposes today. First being for a preliminary examination in file number 24-02761. The burden is on the prosecution there to establish sufficient probable cause that a crime was committed and probable cause sufficient that you, Mr. Beasley, were the individual who committed the alleged crime. This would not be the standard held at a trial. At the trial, they need to prove each element beyond a reasonable doubt. However, we also have a PA 53 conditional release violation that is also being addressed today, which stems from the same set of allegations. And the burden there would be beyond a reasonable doubt that those actions in fact took place. And so the court is going to be the sole determiner and both matters, assessing the credibility of the witnesses and determining if the evidence is sufficient to sustain each burden. We have in the felony matter, again, two counts. One is a felony. Other is count two being a domestic violence misdemeanor. So the court does not need to address any issues of probable cause for that purpose. However, the count one being a felony, 10 years, $5,000 in fines, is an assault with intent to do great bodily harm, less than murder or by strangulation. We had testimony today from Officer Matthew Stevens. His testimony was entered largely under MCL 768.27C, to which the court heard objections first from Mr. Sartz. There was a list of objections to the testimony being brought in, as well as objections to the People's Exhibit 1, which is the dispatch call that was placed that caused the officers to report to the alleged scene of the incident. The court held those objections in abeyance to see that the proper foundation was laid and how the evidence rolled out based on the information that was provided through the testimony of Officer Stevens. The court is satisfied that the foundation was properly laid, that the information that Officer Stevens testified did in fact provide statements by a declarant that purported to narrate, describe, or explain the infliction of a threat or physical injury upon a declarant, and that the action was offered in an offense that does involve domestic violence. Mr. Sartz did argue, particularly as it relates to the reliability of the testimony and the reliability, I believe, of the People's Exhibit 1. I would disagree and find the testimony of the officer to be reliable. He was presented there at the time. He was able to identify the defendant. He stated that he was familiar with the defendant at the beginning of his testimony and that he was present while the defendant was questioned by another officer and later taken into custody. In addition to that, the people have admitted Exhibits 2, 3, and 4, which are photographs of a victim or alleged victim in this matter that purport to show various areas of her body that she allegedly sustained injuries as a result of the statements that was provided via 27C today. In addition, the court finding it appropriate to admit People's Exhibit 1 over objection under 901 B1 and B6 believe that in addition to the other exhibits provides an extra layer of corroboration and or reliability of the testimony. I would agree also with the prosecution in their statement that the recording alone lays enough sufficient evidence, but obviously needing the officer to get that recording in. We have here testimony that the officer reported to the address of 1501 Kennedy, City of Lansing, Ingham County, State of Michigan. We had appropriate identification of the defendant. It stated that he made contact there with a female who was later identified as a LaTanya Burnett. When the court heard evidence under People's Exhibit 1, the court here an individual, a male subject who called 911 dispatch. And it was apparent to the court that there was some commotion going on in the background. It was difficult to hear the second female voice. And then you could hear some distress in the male's voice, indicating that he needed assistance and that this alleged victim was tearing up the place or causing a ruckus, I think what he would repeatedly call for, and that he needed some assistance of some sort. Female could be heard stating she couldn't breathe and that she needed some help in the background. The male identified himself to 911 dispatch as being Willie Beasley, an identified subject that we later know to be the alleged victim is LaTanya Burnett. Officers did speak with Ms. Burnett, stated again that she and the defendant got into a disagreement about some keys and that she was assaulted, that she sustained injury to her hand, abrasions to her head when her wig was ripped off that was glued on. Swelling was noted in her hand and some scratches on her left hand, as well as a laceration on her right hand. There were some marks or abrasions around her neck that she stated she had suffered some strangulation. She could not recall if she lost consciousness, but there was difficulty. She did experience difficulty breathing. Officer Stevens also testified that he did observe items and personal belongings of Ms. Burnett at the property that would indicate that she did reside at that location. And so in order to establish probable cause, the people would have had to establish that the defendant committed a battery upon Ms. Burnett, that the battery is forceful, violent, or offensive touching of another person or something closely connected to that person. Second, that the touching must have been intended by the defendant, that is not accidental, and it must have been against Ms. Burnett's will. It does not matter whether the touching caused an injury. Third, that the battery was committed by strangulation or suffocation. Strangulation or suffocation means intentionally impeding normal circulation of the blood or breathing by applying pressure on the throat or neck or by blocking the nose or mouth. Based on the testimony that was admitted through 768.27C, the court is satisfied as to each of those elements because of the the statements provided that Ms. Burnett was strangled, that she did lose breath or had difficulty breathing, and she wasn't sure if she lost consciousness. Also that she sustained injuries from having her wig ripped off her head, and as well as the other injuries that were noted in people's 2, 3, and 4 of the alleged victims' hand and arm. So count 1 will be bound over to the circuit court for a bind over date of October 16th. Count 2 will accompany. As to whether or not there was sufficient evidence to establish beyond a reasonable doubt if there was a violation of the bond conditions. Mr. Beasley in file number 24-02336 was arraigned by this court, Magistrate Milmore, on August 9th, and certain bond conditions were put in place. There was a no contact order that was put in place as of August 9th. That no contact order did not include an address. However, it states that you're not to have contact directly or indirectly with LaTanya Burnett. You're not to assault, harass, intimidate, beat, molest, wound, or threaten LaTanya Burnett. You're not to be within 2,000 feet of wherever Ms. Burnett is. And that he was not to engage in any assaultive or threatening behavior. I would agree with Mr. Raleigh that we don't have any evidence at all as to support whether or not he had been intoxicated or there was the use of alcohol. And I recognize that there was no address that was provided at the time for the arraignment on the domestic violence misdemeanor file. And that's typical. A lot of 9 times out of 10, the court is not going to have the victim's address unless it's clear in the affidavit of probable cause that both parties live at the same address. However, we have testimony that the officer reported to this address and that there were items there that show that this victim is living at this address. The other concern is whether she lived there or not. It's very clear based on the call where the caller identified himself as Mr. Beasley and identifies the subject in the background as Ms. Burnett, that the officers who later appeared to this location that the dispatcher or that the caller to dispatcher dispatched them to, and both of these individuals are there together, it's a clear violation that they're not supposed to be together, whether they live there or not. So we have beyond a reasonable doubt that there's a violation of the bond conditions. Whether or not, the thing that's question that's concerning for the court is that Mr. Beasley allegedly called 911. Whether or not there was self-defense, that's for his attorney to figure out and plead at to the trier of fact. But as to the violation, I am going to sustain that violation that he was not to be within 2,000 feet of wherever she lives, works, and goes to school. And I recognize we don't know where she lives, but that's also to be construed that he's not to be within 2,000 feet of the victim, and he was aware of that. That being stated, we'll address the sentencing on the bond violation at this time. Yes.
Well, Your Honor, I think as we heard today, I'm both in that recorded 911 call officer. Mr. Beasley maintained that he did not initiate contact with Ms. Burnett, that is, I did not want contact. He was in his home. In fact, I believe, well, just to say, I don't believe we've established that he's responsible for that contact occurring. I would ask the court to issue a sentence accordingly. I'll state that my client has been in custody since, I believe, September 16th, if I'm not mistaken. I'm sorry, 14th of this year. And I would ask that he simply be sentenced to time served for this violation.
Should it be one of you heard it all? I'm not sure if he was hesitant to go as if you were gonna say something.
No, Your Honor.
Okay,
I'll leave it
sounds
at the
good.
court's discretion.
He's been in custody on the violation since September 14th. Let's see. Originally on the domestic violence misdemeanor charge, he had a 300 personal recognizance. There was not a GPS tether requirement. And that's typical because it was a domestic violence misdemeanor without any circumstances at the time that would have caused the arraigning official to believe that GPS tether was warranted. But now I have a new file with allegations of some assaultive or threatening behavior against the alleged victim from that file. And then that PA 53 lists the address that the defendant gave as his address as the victim's address. Does your client have a place where he can stay?
Yes, Your Honor. In the alternative, and especially as it relates to bond moving forward, he currently has a $10,000 cash surety bond on the felony charges. He can arrange for a new place to stay while he works through, he's on a lease with that old administrator, but through the landlord tenant process, he can clear up that issue, but he does have a place to stay as an alternative residence if the circumstances require. Thank you.
The sentencing for the bond violation as 30 days Ingham County Jail with credit for time served. Your bond in the felony is 10,000 cash surety, and there is a GPS tether requirement. You're not to be within 2,000 feet of LaTanya Burnett. You're not to have contact directly or indirectly with LaTanya Burnett. You're not to be in 2,000 feet of wherever she lives. So that's not just where she works or goes to school. You understand that? It could be where she's doing her laundry. It could be where she's grocery shopping. It could be where she worships. It could be where she's studying at the library. It doesn't matter where she is. If you know that she's there, you're not to be there. You understand that? I can't hear you. Okay.
Your Honor, may I be heard briefly as it relates to the cash surety bond and felony charges?
Yeah.
Thank you, Your Honor. I would respectfully request a reduction in terms of the cash surety amount. Mr. Beasley is indigent. Respectfully, of course, he is presumed innocent, but while the prosecutor has deferred for today's proceedings, it will be potentially a lengthy process once we get up to circuit court. Respectfully, there are questions about this case here moving forward, and we've anticipated potential trials down the road. But putting that aside, Your Honor, Mr. Beasley is unable to afford the cash surety amount of $1,000 right now. But if he's released, he does have a stable place to stay in the community. He can stay with his brother and with his mom at a different address while he sorts out the respectful disagreements about the residency of the complaining witness here through the landlord tenant process. If he's out, he's going to try to work. He has deep contacts to the community. He's not a flight risk. He's plenty of people in the locations in the area who can keep track of the location. GPS tether is fine, Your Honor. He'll be able to comply with those conditions, and he certainly has no objection to if the court thinks that's necessary. Your Honor, respectfully, I would just request a reduction in the cash surety amount at this time. Thank you.
The prosecution wants to respond to the motion.
Your Honor, ultimately, with noting that there was a final pretrial domestic violence that was dismissed today with the exact same victim simply because she failed to appear, and my inability to contact her, I think I would have to object to a reduction in the bond. If Your Honor is to grant it, though, I would just request to be done with GPS tether and victim notification if possible.
Let's see. I think GPS tether in this situation would be sufficient enough to secure Mr. Easy from any violations, I would hope. Are you still employed, sir?
Anymore.
Bond will be reduced, 10,000 personal recognizance with GPS tether, 2,000 feet victim notification if possible. And it will reside at the address, I think it's 4330 Keller Road, apartment 16. Your phone number still ends in 1546. I can't hear you, sir.
Yeah.
Okay. Do you have any questions about your bond? Any additional matters for the record?
Nothing from people.
Nothing for the best, Your Honor.
You're all set.
Thank you, Your Honor.
No problem. Let's see. Simpson was not supposed to be on the docket, okay. I believe Simpson was supposed to be on the docket. That was an error. I think it's. Are we ready on Shaw?
People are ready.
Matthew Shaw.
I could just have a brief recess, Your Honor, just to use the restroom.
Absolutely.
The allegations of witness intimidation, then, Your Honor, we also have a report dated 9/14 that's older, and that was the one I thought we were here on.
Yeah, that's-
Regardless, it's the
one I
same
had.
witness for both. I just don't know if Mr. Austin is prepared on the second. That's the only reason I bring it up.
I have one for the first and 14.
Right. Yeah, that's the one.
Yes.
This report, judge is saying she has a judicial investigation for it. Judge says she has one. I haven't seen it yet either, so.
I
I have what report?
The one for the incident alleged to have occurred on 9/24, Your Honor.
Yeah, from the sheriff's credit.
Yes, Your Honor.
She can forward that to you. Oh, I think it was forwarded to you.
Yeah.
September 26th.
Yeah, I got the report. I didn't know if there
For
was.
both officers. I mean, for both attorneys.
Yeah. That's what we received. I'm not sure.
So we have the police
have
report,
the
Your
actual
Honor.
police
It just
report.
doesn't have a actual PA 53 violation report from probation services yet, so that was, I think.
It is.
You're saying that you don't have a complaint, a violation of conditional release.
Correct, Your Honor, for the incident on 9/24. I don't have it.
I don't get one when they violate the GPS tether either, but it's still a violation.
I'm ready to proceed on it, Your Honor. I just,
Yeah, I think this week probation just forwarded this. This is what happened, I
Yeah.
believe.
yeah, I'm ready to proceed on both, Your Honor. I think it's a violation. I have the same officer here for both, so. Your Honor would like to arraign him on the second violation. I'm ready to proceed on both. I don't know if Mr.
That
Austin.
But it was sent to Mr. Austin on what day? The 26th?
Well, I have the report. I'm in receipt of the police report, Your Honor.
Okay. You needed to take a quick recess, didn't you?
Yes, Your Honor.
Let me do that now.
Yes, Your Honor. Thank you.
Okay, on the record in the matter of the people of the state of Michigan versus Matthew Shaw, 24-01459. Council appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
And thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Shaw. He stands present to my right.
Okay, I have a sentencing today and a PA 53 hearing scheduled. We will proceed on both. Is that correct?
People are ready to proceed, Your Honor.
I'm ready to proceed on both as well, Your Honor. I would just note as it relates to one of the bond violations, I don't know if Mr. Shaw has been arraigned on the latest one yet. That is the only thing. She really made it,
Okay, sounds good. Okay, Mr. Shaw, I do have here a report from the Ingham County Sheriff's Office. It's dated having occurred back on September 24, 2024, at approximately 8 a.m. It says from 630 North Cedar Street in Mason. The allegations are that you allegedly violated the terms of your bond conditions in a no contact order by making or attempts to make contact. It's like both contact and attempt to make contact with the protected party in this matter. And the report lists a series of recorded messages. So you have the right to have a contested hearing. You have the right to be represented by your attorney at that hearing if you are found to be in violation of your bond. Your bond could be revoked. You could be subject to contempt of court sanctions, punishable with a maximum penalty of 93 days in jail. Do you understand that?
Yes.
Okay. And so at this time, the court's entering a plea of not guilty on your behalf as to these violations, and we're prepared to proceed with the hearing today, okay? Do you have any questions? You can have a seat and then you can call your witness, Mr. Mercury.
Yes, Your Honor. Before I call him, just as a housekeeping matter, I believe we're here for 3 total violations. There are 3 separate reports, an incident dated September 1st, 2024, another one dated September 14th, 2024, and a third dated September 24th, 2024 that you just arraigned.
That's my understanding as well.
Thank you, Your Honor. People call Officer William Bellinger to the stand.
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat. You can state your first and last name and spell both.
Deputy William Bellinger, Bellanger.
Thank you. Proceed, counsel.
Yes, Your Honor. Thank you. First, my apologies. I called you Officer Deputy Bellinger. Thank you for being here with us today. Are you currently employed?
Yes,
Where?
Ingham County Sheriff's Office
How long have you been employed at the Ingham County Sheriff's Office?
since August of 2014.
Did you have any prior experience on any other police force before that?
No.
So going on about a decade.
Yes,
What's your current rank and assignment?
I'm a deputy assigned to the Field Services Division out County Patrol.
What does a deputy assigned to field services generally do as a part of your job?
Respond to calls for service, enforce traffic laws, conduct business property checks, and other community policing functions.
In your experience in this role, have you ever responded to a call from dispatch regarding a violation of a conditional release order, or maybe more commonly a PA 53 violation?
Yes.
You approximate how many times?
I've personally been dispatched twice for, I guess, this specific incident, over the course of my career, no, like many.
More than 100?
Probably not that many, but quite a few.
Okay. Now, regarding this specific incident, do you know a suspect by the name or an individual by the name of Matthew Shaw?
Yes.
How do you know Matthew Shaw?
I came to know him and have contact with him throughout my response to calls for service.
Would you recognize Matthew Shaw if you saw him again?
Yes.
Do you see him in court here with us today?
Yes.
Could you please point him out and identify him by an article of clothing he's wearing?
He's sitting here wearing an Ingham County Jail uniform, blue and color.
You're going to let the record reflect Deputy Bellinger has identified the defendant.
Any objection?
Without objection.
So noted.
Do you know a person by the name of Camille Weiss?
Yes.
How do you know Camille Weiss?
Again, I came in contact with her via calls for service, being dispatched.
We've talked a couple times about calls for service and you being dispatched. Before we get to these specific dates and incidents in question here, I want to address, are you aware if Mr. Shaw was on some sort of pretrial release when you responded to these calls?
I wasn't immediately aware, but throughout the course of the investigation, I learned that yes, he was.
What, if any, conditions were the terms of his pretrial release?
The one specific was that he was not going to contact with Ms. Weiss.
Would it be fair to say that that's how you ended up getting dispatched and came into contact with both of these individuals?
Yes, on one occasion. The first occasion started with a different individual, but then it led to the connection with Ms. Weiss.
Let me get right into it so I don't have you guessing up there. On the date of September 1st, 2024, did you participate in an investigation regarding Matthew Shaw?
Yes.
Did you respond to the location of 103 Vive Drive, South Mesa?
Yes, I don't think I physically responded to the house on that day, but I conducted an investigation over the phone.
Fair enough. What's at that location?
That is the home of Samantha Gibson, and Camille Weiss is currently staying with her at that home.
When you say she's currently staying with her, do you mean on the date of September 1st, 2024?
Yes, and from my understanding, prior to that, and still to this day.
Do you have any information on whether or not the defendant knew she would be staying there?
Sure, I'm going to object to call it speculation.
Your question was whether you knew the victim would be staying there?
Whether the defendant had any information or knew that the victim would be staying there, yes or no?
Or maybe it doesn't call for speculation. He might have information, so the objection's overruled.
Do you have any information that indicates whether the defendant knew Miss Weiss would be there?
Yes, I was advised that by Miss Gibson that she had been staying there. He knew that she was there.
I would object to hearsay.
Did you want to respond to the objection?
Yes, Your Honor. Your Honor, I'll rephrase.
Thank you. I was gonna say, I don't think his response would have answered, but that he had information anyway, so I was gonna go back, circle back and sustain the previous objection, so.
Yes, Your Honor. When your officers responded to the location of 103 Vive Drive on September 1st, 2024, what happened?
I made contact with the reporting party, Samantha Gibson, over the phone.
Why were you dispatched to this location?
Originally, it was a harassment complaint on behalf of Miss Gibson.
As a part of the dispatch or the complaint, was there a statement identifying the suspect or the person of interest?
Yes.
What was that statement of identification?
I would object to hearsay.
Did you want to respond to the objection?
Yes, Your Honor, this is a non-hearsay statement of prior identification under MRE 801. D1C.
Objection's overruled.
So did you have a statement of identification identifying who this suspect was of the harassment?
Yeah, she told me it was Matthew Shaw.
When you arrived and made contact with Ms. Gibson, what, if any, evidence did you see to corroborate this harassment complaint?
So I spoke to her over the phone, and she had told me that Mr. Shaw had been coming over to her home on a.
Let's,
Check the hearsay.
let me lay some foundation, Your Honor. I'll rephrase. It's fine.
Objections suspended.
You said you spoke to her on the phone. Before
Yes.
we get to what she told you, can you describe what her emotional state was at this time? Was she happy, sad, upset, depressed, whatever?
Nothing specific stood out to me.
Was she yelling? Was she speaking loudly?
No.
Did she seem affected by the recent harassment complaint?
Yeah, I don't know, I can't say exactly, but it was a normal conversation with her.
Do you have an idea of how long after this complaint was called in, you responded?
Usually, since it was over the phone, it was probably pretty close to immediately after she talked to this guy.
And were her statements, generally speaking, were they describing what had just happened?
Yes.
Please tell us what you said.
Your Honor, I would object to hearsay.
I think we've laid the foundation for a present sense impression at this point, an exception to hearsay under MRE 803.
Well, may I respond to that, Your Honor? Yes, the witness stated he can't be certain exactly how long this conversation took place after whatever had occurred. So I think based on that, we don't have a proper
He
foundation.
said
for
he couldn't be certain, but he said immediately too.
Yes, sir.
So maybe he can't tell you the exact time, whether it was 3 minutes or 15 minutes. But he is stating that it was immediately. So that would, to the court, cause me to presume that that was within a short time frame. It's immediate, an immediate response. So the objection is overruled.
Yes, sir. Thank you. What did Ms. Gibson tell you had just happened?
She advised me that over the course of several days, Mr. Shaw had been coming to her home on a nearly daily basis.
Your Honor, I would object in the hearsay on that. That is not a present sense impression if they are, if the witness is now describing a multitude of events over a multi-day period. That is not something, describing something that just presently occurred. Now we're getting into instances that happened well before that. So that would fall outside the scope of that exception.
Yes, Your Honor, it's the exact same conversation that you just overruled the hearsay objection on. She is testifying to the reason that, or he is testifying to what Ms. Gibson was telling him that the reason for her complaint he responded to that day was for, that you already found a valid exception for 803.14. It's contextual, Your Honor. We can't just parse up the statements here or there. It has to be the statement in its entirety.
Agreed. She's describing why she called the police at that time, and in describing that, she's laying some foundation as to the nature of her concern as it relates to Mr. Shaw. So the objection is over.
Let's try this again, Deputy Bellinger. What did she tell you had happened? Why was she calling police?
Again, she felt like she was being harassed by Mr. Shaw as he had come to her home multiple times, nearly every day over the past several days.
During that conversation, did you have information on Miss Weiss's whereabouts, where she was located?
So I had inquired as to her relationship with Mr. Shaw and why he would be coming over to her house, and at that time she informed me that Miss Weiss was staying with her due to a recent court or domestic altercation between the two of them at their home.
On the date of September 1st, 2024, when you responded to Samantha Gibson's complaint about the defendant, did he have a valid pretrial release order in effect?
Yeah.
Was that pretrial release order the same one we've talked about with the condition including not to contact Camille Weiss?
Yes.
Do you know of any other conditions that were present in that pretrial release order?
Not
Do you
specifically.
recall them off the top of your head? Have you seen that pretrial release order before?
Yes.
Would it refresh your memory if I approach you with a copy of it?
Yes.
Your Honor, I think we have a stipulation. I won't need to refresh the witness anymore. Stipulation to the conditions of the pretrial release order, those being 3
So noted.
conditions of 1, not to assault, harass, intimidate, beat, molest, wound, or threaten the following persons, Camille Weiss. The second, for no contact with Camille Weiss, direct or indirect. And the third, to not go within 2,000 feet of where the victim lives, works, or goes.
Your Honor, I would stipulate that was about court order and that Mr. Shaw was aware of those conditions on the dates we're going to be talking about during the course of this hearing.
Thank you.
Did you attempt to contact Mr. Shaw on that date of September 1st?
Yes.
What happened?
I wasn't able to locate him.
Why not?
What's that?
Why not?
I'm not sure. I stopped at his mother's home as well as his home, and I attempted to call him as well. And he wasn't able to locate it.
Let's move on to the date of September 14th, 2024 now. Do you know if that pretrial release order was still in effect at this time?
Yes.
Did you at some point get dispatched to another call at the location of 103 Vive Drive, South Mason, Michigan?
Yes.
To be clear, that location that we've talked about in both these incidents now, is it in the city of Mason?
No, it's in Vive Township.
Vive Township?
Yes.
Is that in Ingham County?
Yes.
State of Michigan?
Yes.
What happened with regarding the September 14th date?
On that day, we had received an 911 call from Ms. Weiss advising that Mr. Shaw was at the home and actively attempting to enter.
Did you respond?
Yes.
What, if any, corroborative evidence did you find upon your response to this attempt to invade her home?
When I arrived on scene, Mr. Shaw was standing in the front yard, having a conversation with another male subject, one of the other.
You know who that other male subject was?
I think his first name's Dale. Scheid or she is how you say that. SCHEID.
How does Dale relate to all this? Do you know?
He is the significant other of Miss Gibson.
Fair to say that this 103 Vive Drive still Miss Gibson's home?
Yes.
Perhaps that's why Dale, or I won't put words in your mouth, with it being Miss Gibson's home, why do you think the defendant was communicating with Dale upon your arrival?
Objection, that calls for speculation.
That's a dog cause for speculation.
Fair enough, Your Honor. I'll rephrase.
Objection 16.
Upon your arrival then, if I have it correctly, the defendant was talking with Dale.
Yes.
Dale is Samantha Gibson's significant other.
Yes.
This home is Samantha Gibson's home.
Yes.
What, if any, conversation could you overhear between Dale and the defendant?
I didn't hear any conversation.
What, did you make contact with the defendant at this point?
Yes.
What happened?
I placed him under arrest.
Did he give any statements to police?
Not to me.
Why did you place him under arrest?
I knew that there was a court order in place and that he was not allowed to be around Miss Weiss, and he was in violation of the court order.
To be clear, did you find Miss Weiss at this location on September 14th?
Yes.
To be clear, she was also the one who called in on September 14th.
Correct.
Moving on to the date of September 24th now. The location I have is 630 North Cedar Street. Is that an accurate location for any investigation you did?
Yes, that's the address that Ingham County Jail.
Why would the Ingham County Jail be listed on this report?
Mr. Shaw was incarcerated in the jail at that time.
Okay, well, let's talk about why there was a report on September 24th then while the defendant was incarcerated. What happened?
I received a phone call from, I can't remember the woman's name.
Would refresh your memory if I approach you with a copy of your report?
Yes.
Approaching the witness with a copy of his report. Just look at that, read it silently, and look up at me
Yep,
whenever you've been
I
refreshed.
got it now.
Has your memory been refreshed?
Yes, thank you.
Who was the person that you spoke to?
Deborah Woodman.
What happened when you spoke to Deborah?
She advised me that she had recent contact with Miss Weiss and that Miss Weiss had told her.
Object to hearsay.
Answer the objection.
Yes, Your Honor. At this time, I'm not using any of Miss Woodman's statements for the truth of the matter asserted, if I may proffer.
Okay.
My understanding that all she did was call in the alleged jail calls. Officer or Deputy Bellinger did his own investigation in the jail calls and found them himself, so we don't need these for the truth of the matter asserted. It's just showing next steps of the investigation.
Objections overruled.
Please continue with where you were at. Sorry.
So she reported to me that she had been in town to help Miss Weiss move out of her home, at which time Miss Weiss disclosed to her that Mr. Shaw had been contacting her in the county jail.
Did you take any efforts to investigate this accusation?
Yes.
What did you do?
I contacted the jail sergeant at the time, who was able to look at phone call logs and messages and provide me with.
Would it be fair to say the defendant was attempting to contact Camille Weiss?
I don't want to reject. I think there's a lack of foundation at that point as to how he would know Ms. Weiss in particular if he was attempting to contact. So I think we're missing some foundational steps before we can get to that conclusion.
It's not here.
I can lay some more foundation, Your Honor. I might have missed it, but I thought Deputy Bellinger already testified to the fact that he reviewed these calls, but I can lay that foundation at the end. Thank you. These calls and messages, are they somehow recorded?
Yes.
Are you able to look at those?
Messages, yes. Look at calls, listen to, yes.
Did you look at the messages and listen to the calls that we're about to talk about in this case?
Yes.
Are you familiar with the contents of them?
Yes.
Who was the defendant attempting to contact in all of these calls and messages?
Miss Shaw, or Miss Weiss.
How do you know that?
Throughout the various calls, a couple of them called her by name. The messages were specifically addressed to Camille.
So I've got a report here indicating approximately 25 calls and messages. Does that sound right to you?
Yes, I believe there is 25 calls that were placed, not all of them were answered. And the messages, I think there was maybe 5. I should tell you exactly, but
That's okay. I am not going to waste the court's time by going through all 25 of those. I'm going to try to summarize this for us. In those 25 either successful or attempted contacts from the jail, who was the defendant attempting to contact?
Miss Weiss.
Did he ever actually make contact?
Yeah.
Can you generally summarize what the defendant has been saying to Miss Weiss in all of these calls?
So they vary. You know, there's a lot of talk about the kids, talk about the day, what they were doing. Some of them escalated into arguments. There was accusations of infidelity, some name calling, and discussions of the ongoing court case.
Does the defendant ever raise his voice with Camille Weiss?
Yes.
Did he ever get aggressive with Camille Weiss, in your opinion?
Verbally, yes.
Does he ever threaten Camille Weiss?
I don't think he specifically threatens her.
Fair enough. Thank you, Your Honor. I have no further questions.
Council Sam.
Thank you, Your Honor. Good afternoon, Deputy.
Good afternoon.
So kind of starting backwards here and moving forward, the September 1st incident that you were talking about. That is when you said you had contact with Samantha Gibson, is that correct?
Yes.
And that was strictly over the phone, is that correct?
Yes.
And you essentially relayed to the court what Ms. Gibson had told you, is that correct? And you were not able to independently corroborate or tell us what she was telling you had actually occurred. Would that be a fair statement?
Say that again?
Sir, do you have independent knowledge of what Ms. Gibson was telling you over the phone had in fact occurred? In other words, did you witness personally any of the events that she was describing you that had occurred on either September the 1st or in the days preceding?
I did not personally witness that point.
And you did not witness Mr. Shaw at the residence that we've been talking about on that day on September 1st, is that correct?
That's correct.
And you did not have any contact with or speak with Ms. Weiss on that day on September the 1st, is that correct?
That's incorrect.
The contact you had with her, was that over the phone?
Yes.
And so now moving forward to a couple weeks later on September the 14th. That is when you said you had responded to a 911 call, is that correct?
That's correct.
And said you witnessed Mr. Shaw interacting with a male subject named Dale that was kind of in the front yard of the residence, is that correct?
Yeah, Dale was on the porch or on the bottom steps of the porch, and Mr. Shaw was in the yard in front of it.
And whatever the nature of the conversation was they were having, you said you weren't able to really overhear it, is that correct?
No, I interjected myself.
And you did not witness Mr. Shaw, he was not in the vicinity of Miss Weiss, is that correct?
She was inside the home.
And Mr. Shaw was on the outside, correct?
That's correct.
You did not witness Mr. Shaw conversing with Miss Weiss on that day, is that correct?
That's correct.
And you did not see Mr. Shaw in proximity to Miss Weiss on that day, is that correct?
Yeah, she was inside the home, door was closed.
Okay, and Mr. Shaw was outside, correct?
Yes.
And the jail calls that you were talking about, you said there were 25 calls between Mr. Shaw and Miss Weiss, is that correct?
There was, yes, I believe 25 total calls, not all were answered.
And do you know how many of those calls were completed or successful of those 25 calls?
Not off the top of my head.
Do you know if the majority were successful calls or unsuccessful calls?
I think probably a few more than not, but it was pretty even.
And in a lot of those conversations, they were just talking about their lives, their children, and common and so forth, correct?
That's generally how the conversation started. But it would generally escalate as it.
But as you stated, they were talking about their family and so
Yes.
forth, correct?
Yep.
And you did not hear Mr. Shaw specifically threaten Ms. Weiss. That was your testimony. Is that correct?
Yeah, that's correct.
Thank you, Dixon.
Maybe direct.
Yes, Your Honor, briefly.
Do you remember exactly off the top of your head the split up between the 25 calls of how many were answered, how many weren't, anything like that?
No.
Would it refresh your memory if I approach you with a copy of your report?
Yeah.
Deputy Bellinger, please review that report. And I think it might be easier to count how many calls were not answered. And when your memory has been refreshed on how many were not answered, let me know. How many calls out of the 25 total were not successful?
9.
So only 9 out of 25. Fair?
Yeah.
You were asked on cross about what you did or did not personally observe. Let me be clear. How often in your 10-year career have you personally observed a PA 53 violation happening in real time?
Chapter relevance.
What's relevant?
Your Honor, I think it was a hint at an attack on the credibility of the investigation here. All I'm trying to prove and why this is relevant is that it's very unusual to actually be there as an officer when a violation is happening. These things get reported and then an investigation occurs as the normal course.
Well, if I may, Your Honor, it wasn't an attempt at attacking the credibility of the officer. I was just pinpointing what he was able to personally tell us that he observed versus what he did not personally observe. So I still maintain my objection to relevance to that.
It's a fair cross question, Your Honor, but that doesn't mean I can't ask about it again on the redirect. That's all my point is.
Your question was how many times in the course of his duty as a deputy has he actually observed?
Yes, Your Honor, and I could rephrase that too to make it more relevant, but I think it's relevant.
Objections overruled. You can answer.
How often in your 10 years as a deputy have you actually been there to witness one of these violations happen?
I couldn't give you an exact number over the last 10 years, but I'd say more often than not, the suspect is not still on scene when they're called in.
Fair enough. No further questions, Your Honor.
This deputy be excused.
Yes, Your Honor.
Thank you, Deputy Bellinger.
Thank you.
Excused. Any other witnesses today?
No, Your Honor, people rest.
And will the defense be calling witnesses?
We'll rely on the evidence presented, Your Honor. Thank you.
Thank you, Mr.
Yes, Your Honor, thank you. As Your Honor is well aware, although it took us all a little bit of double checking and confirming here before we started, we are here for 3 separate PA 53 violations for the defense. When I'm making my argument, I will refer to them by date just because I think that's a little easier since they all involve similar conduct. First violation was on September 1st, 2024. Second violation was on September 14th, 2024. Third violation was on September 24th, 2024. We have a stipulation to the terms of the pretrial release order. I won't repeat those since we already have them placed on the record, Your Honor. Regarding the first incident on September 1st, we had testimony from Deputy Bellinger stating that a Samantha Gibson called to report a harassment complaint, advising that the defendant, Matthew Shaw, had been over to her house where the victim, the protected party, Camille Weiss, was staying several times over the course of a few days, and this just happened to be the time she finally reported him for it. Not only that, he stated that she was attempting to get inside of the home, as well as making some comments directed at Miss Weiss, was the testimony that we had today. Although Deputy Bellinger didn't arrive on scene and see the defendant that day, the defendant was identified prior to going there. We had the prior statement of identification on the record, and that would be a violation of a no contact order on top of the potential violation for do not harass Camille Weiss or be within 2,000 feet where she lives, works, or goes to school. Now, referring to the second violation on September 14th, Your Honor, as Deputy Bellinger testified, the defendant was there this time, standing right in the driveway, arguing with Dale Schneid, Samantha Gibson's significant other, at the exact same location where Camille Weiss was still known to have been staying. I anticipate there might be an argument made that the defendant had no clue Camille Weiss was at this location. However, Your Honor, going there once on September 1st, getting a report filed for attempting to contact her then Then going back again on September 14th, I think we have circumstantially proven beyond a reasonable doubt this defendant knew exactly where Camille Weiss was staying. He was attempting to get in contact with her, and if not attempting to get in contact with her directly, he was at the very least attempting to continue to harass, intimidate, threaten her, and he was within 2,000 feet of where she lives, works, and goes to school on both dates. Regarding the September 24th violation, Your Honor, we have a list of 25 jail calls, 25, only 9 not being answered. That leaves 16 contacts between this defendant and Camille Weiss, the protected party, where each conversation starts off almost the same, of talking about family, talking with her about the kids, and then escalates into him raising his voice with her. Deputy Bellinger made clear he did not think he ever directly or specifically threatened her, but he certainly raised his voice and yells by the end of all of these conversations. 16 times from jail, Your Honor, he's attempted to contact her. As you are well aware, we could have proceeded for a single violation every single time he attempted to contact her. Instead, I'm asking for convenience that we lump all those together into one sole violation for the date of 9/24/24. Thank you.
Thank you, Your Honor. Kind of going backwards, as it relates to the September 1st incident, Your Honor, essentially what we have is what Miss Gibson told the deputy. Now, I have no doubt what the deputy said was true, and that I think he is repeating as best he can the nature of the call that Miss Gibson made to him. However, I do think it is important to note that there is zero independent evidence or corroboration of what Miss Gibson was telling him had actually occurred. We don't know what motive Miss Gibson may have to lie or fabricate those allegations against Mr. Shaw. We don't know what bias that she may have against him. And we would not have been able to explore those because she wasn't presented here so that she could have been cross-examined on those. So I think that is an important distinction. So there is no independent corroboration as to the September 1st incident of what Ms. Gibson is alleging had actually occurred. We merely have the deputy repeating what he was told happened. Now, as it relates to the September 14th incident, where it appears that Ms. Weiss was at that home. However, I do think it's important to note that Ms. Weiss was inside the home, Mr. Shaw was outside the home, and the deputy did not witness him, Mr. Shaw, having any contact or attempting to have any contact with Ms. Shaw while he was, or Ms. Weiss while he was there. And I think
why is it important for us for the court to note that he was outside the home, that she was there? Because if I note that, that means that he would be in violation of the no contact order, though, wouldn't it?
Well, that's what I was getting to, Your Honor. It may vary. We don't know what Mr. Shaw knew at that time. It may very well he went there not knowing Miss Weiss was there. And so it would be my argument to the court, if he went there not knowing that she was residing there, because we do know the testimony sounds like it was undisputed that was not Miss Weiss's home. Maybe she was staying there permanently, temporarily, it was unclear, but it was certainly not Miss Weiss' home. It was Miss Gibson's home. And my argument to the court would be, Your Honor, we don't know what Mr. Shaw's knowledge was when he went there. He may very well have went there not knowing she was there. And if that is the case, if he did not go inside, if he did not have contact with her or attempt to have contact with her, he was merely having contact with the other person. My argument to the court, Your Honor, is that he did not knowingly or intentionally violate either the no contact order, or he did not knowingly or violate the exclusion as it relates to how many feet he's supposed to be away from Miss Weiss, wherever she is living or residing. if he did not know that. And I think the evidence is certainly unclear and arguable on that. And I'm asking the court to conclude that Mr. Weiss is not guilty for that reason as well. As it relates to the jail calls, Your Honor, I think that evidence and testimony speaks for itself. I think the court can carefully evaluate the evidence and testimony on that and make the conclusion, whatever the court's holding on that is going to be. But for the other reasons that I've stated, Your Honor, I'm asking that the court find that Mr. Shaw did not violate his pretrial release conditions.
Any further on it? Okay, so again, we have testimony from Deputy William Ballinger from the Ingham County Sheriff's Office in reference to three separate reports of violations. I'm stating that specifically in that form because one of these reports of violations actually contain multiple violations. Nonetheless, the first being the allegations of violating the pretrial release order of this court on or about September 1st. So Mr. Shaw was arraigned in this court, believed by Judge Ward. I was back on the 15th of May. And during that time, there were several conditions of the release order, one of which being not to harass, intimidate, beat, molest, wound, stalk, threaten, or engage in any other conduct that would place any of the following persons or child of the following persons in reasonable fear for bodily injury, that being your spouse, former spouse, individual with whom you have a child in common, a resident or former resident of your household. It also states that Mr. Shaw was not to assault, harass, intimidate, beat, molest, wound, or threaten Camille Weiss. It also states that Mr. Shaw was not to have contact or cause any third party to have contact directly or indirectly with Camille Weiss. It also states that he was not to be within 2,000 feet of the victim's home, work, or school. There was a release with GPS tether with possible notification to the victim. And so the testimony of the deputy was that on the date of September 1st, that he reported to the address of 103 Vide Drive, which he said was in Vide Township, but in Ingham County. He described that to be the home of someone by the name or last name of Gibson, who indicated that the protected party in this matter, Ms. Camille Weiss, had been staying with her and that she was concerned about harassment and that there were multiple visits to her home over the course of the last couple of days or the days preceding the September 1st date from Mr. Shaw. And officer did testify that he did speak with the protected party over the phone. Officer said he immediately responded to the home or the address provided by Ms. Samantha Gibson, but that he did not make any contact with the defendant at the time, that he did make attempts to contact him, but that was unsuccessful. The defense is arguing that there's been no independent corroboration of the allegations that were stated. In addition, we have witnessed here, that being Officer Ballinger, but we didn't have either Samantha Gibson here to help corroborate any of these facts and or Ms. Weiss present. I tend to agree with the defense in that I don't know that the court has beyond a reasonable doubt as to the allegations of the violations for September 1st. So the court's going to dismiss those. Then there were allegations of violations September 14th, 2024. And those allegations, officers received a dispatch call again to the address. The address from the September 1st one, 103 Vive Drive. Also, again, Vive Township in Ingham County. The caller advising that the defendant, Mr. Shaw, was at her home trying to invade the home. Officers arrived, defendant was present. Defendant was having some level of a verbal interaction with the person identified as Ms. Gibson's significant other. Deputy did not overhear any of the conversation, but did place the defendant into under arrest for being in violation of the no contact order. Officer having previously been advised that the protected party was residing there. And this officer testified that he had that knowledge both from Ms. Gibson and from the victim, and the victim having been the person who called 911 on this date and time. And it is on the property of where the protected party lives at the time that the officer arrives. The court is satisfied beyond a reasonable doubt that there was a violation that occurred on September 14th of the bond conditions, primarily the no contact order. Now we have the report from September 24th, which evidences a list of attempted communications, calls and or messages from the Ingham County Jail to an individual identified as Ms. Weiss. About approximately 25 calls or messages were noted, and I believe only 9 of those calls were unsuccessful. And officer testified to having reviewed these phone calls and the nature and the communication in those phone calls. Again, this report was provided to the court prior to the arraignment on the bond violations, until the court did review portions of the report to determine if we would proceed with a bond violation. And it should be noted that some of those communications in the report make it clear that the defendant was aware that the victim was living there. He had a concern about living there and he wants her to live with his mom. That's a whole nother issue. Based on the testimony, the court satisfied beyond a reasonable doubt as to the violations having occurred from the jail with contact directly in violation of the no contact order with the protected party from the report of September 24th. So the defendant will be sentenced on those 2 violations, and then he is scheduled for sentencing today. On the underlying charge of domestic violence aggravated. And the court does have a report that's said it was prepared back on September 23rd, 2024. Counsel, did you get a copy of that?
I received a copy of that report, Your Honor, and I have reviewed it. I have read over it.
Is there reasons to make corrections, updates, or deletion?
No, Your Honor.
Okay, indicates that he has a pending matter in 55th and Felony. That's one.
Yes, Your Honor, that is essentially the basis for the violations that the court just heard. I believe those matters are scheduled for preliminary examination next week.
You can address the court on sentencing.
Yes, Your Honor, thank you. As it relates to the sentencing on the underlying matter, Your Honor, a few things to note from Mr. Shaw. While he was on pretrial release, he was always working, he was gainfully employed. The court has allowed him on multiple occasions to travel out of state for his work so that he can maintain his employment. And he did so without incident on any of those occasions. He had recently changed and gotten another job just recently prior to his incarceration. I know Mr. Shaw has been very emotionally invested in his relationship with his children. And certainly that is, I think, a big motivating factor for him and in his life. Sounds like from speaking with Mr. Shaw and his mother, who was present in the courtroom today, and shortly before he was incarcerated on these violations and these new charges, that he was starting to look into getting help and getting treatment. So I think he had that realization that he has some type of problem that needs to be addressed. And I think the prior conviction that the pre-sentence report noted that he had out of state, I would note that that was approximately 15 years ago. So it appears there's a really significant amount of time for Mr. Shaw involvement in the criminal justice system. So I can certainly understand the probation department's recommendation that he's not a good candidate for probation at this time, simply because he has the other pending matters, and we're not sure how, if, or when those are going to resolve. What I would ask the court to do, Your Honor, is take into consideration the amount of time that he has currently served on this file, which I believe is 29 days as of today. I would ask the court to sentence him to a term of time served on that. If the court believes that more incarceration is warranted beyond that, I would certainly ask the court to sentence him to far less than the maximum amount, which is what the probation department is recommending. As it relates to the contempt findings, Your Honor, I would incorporate my previous statements on behalf of Mr. Shaw. And again, I think this has been a very emotional time for him, being away from Miss Weiss and his children. It's not an excuse for his behavior in this case, but I would ask the court to take that into consideration. And I would ask the court to a nominal jail sentence in the contempt proceedings not to exceed 30 days. Thank you.
Do your client want to make a statement at all?
Yes, Your Honor. I'd like to sincerely apologize to the court and my family. Sure, my mother's sister. Take full responsibility and accountability for my actions. Like my attorney said, I was trying to seek treatment. Actually, I had a bad date for a treatment center the day that I was arrested. I would like the opportunity to get some kind of help and better myself. Not continue to put my family through this. Possible with the other judge that I've seen on my other charges in Mason. He said that I could seek treatment. So by the 15th, I should have some kind of answer on being able to go to treatment in that court. So possible, hopefully. Drug treatment.
Seek treatment for what?
Mental health and drug abuse. Anything I can do.
I'm glad that you recognize you need some help. I understand the judge says you could. And it's possible that you may have a bed and get some treatment offered to you, but unless you're willing and ready to take it seriously, it's not really meaningful. As I look at you, you strike me as someone who's struggling emotionally and obviously physically with whatever is going on with the substance abuse. I don't have before me an assessment that tells me what the underlying issue could be as it relates to substance abuse. I just know I have your criminal history here. I have, although it was charged as 3 separate violations, one of which have 25 attempted calls, which could have been charged separately. It's a blatant disregard of court order. Your criminal history reflects a blatant disregard for court orders as well. I recognize that you, as your attorney said, were granted an opportunity to travel for work and that was successful. That does not absolve the fact that I'm looking at your criminal history. I see contempts on here. I see a history, more than just one conviction in another state. Maybe your attorney is not aware of that, but there's assaultive history in another state. Both felony and misdemeanor. Then there were charges of assaultive actions that were dismissed, but the fact that you have this many charged assaultive and then also substance abuse actions in other jurisdictions is concerning for the court. Our probation department met with you. They don't believe you're a good candidate for probation. They say you have a high risk, moderate to high risks on their assessment and your criminal history. And then the fact that you were remanded on a large amount of violations to the court order. It would not be meaningful for me to put you on a term of probation because I don't think you are healthy enough within your mind to comply with court orders. I think right now you're controlled by other things. You're controlled by your emotions and you're controlled by whatever substance it is that has a chokehold over you. And until you get those things under order, both control over the substance and control over your mind, you're not going to do any good to yourself or your family or your children. So the court really has no choice but to impose a jail sentence because you're not a good candidate. As it relates to the underlying cause of action that you pled guilty to, which was an aggravated domestic violence. The court is going to adopt the recommendation of probation. You'll be sentenced to 365 days in the Ingham County Jail with credit for 26 days. Be screened, if not already being screened by 55th District Court for mental health and substance abuse. And you can be released directly into inpatient treatment if a bed becomes available. I'm continuing the no contact order. You have to have contact directly or indirectly with no lease. Do you understand that?
Yes, Your Honor.
You have to be within 2,000 feet of wherever she is. That's not just where she works and where she lives or where she goes to school. That's also where she grocery shops, where she gets her hair done, her nails done, where she jogs. Wherever she is, you're not to be within 2,000 feet of that. You understand that? Okay. If successful in treatment, you can, I don't know how long he'll end up in treatment, but I'm sure it will be for 365 days. The remaining balance of the 365 days can then be converted to probation oversight, okay?
Thank you.
Let's credit this. I don't think he has more than 26 days at this point. Let's see. I have a total of 47 days. Is that what you have?
That would sound correct to me, Your Honor.
Have present 47 days. As to the probation violations. I'm sorry, the bond violations. Credit time served for those violations on the 14th. You're gonna serve 30 days in county jail for the violation from the 24th report. And that can be suspended if you are transferred into treatment, okay? Do you have any questions about your sentence? Okay. Any additional matters for the record, counsel?
From the people.
I have nothing additional on behalf of Mr. Shaw, Your Honor. Thank you.
You're all set.